The Royal Commission into the Robodebt scheme is now in session. Please be seated.
Yes. Are the appearances today any different?
May it please, Commissioner, I appear with Miss Berry today.
Yep. And Ms.
Commissioner, this morning I appear with Ms Kelly, and I think Mr Glover will be here at lunchtime.
I very much hope so.
Yes, for the other matter.
Yes.
Commissioner, I understand you have been provided a list of exhibits for today's proceedings.
Yes, I have.
I tender the documents in that list as per the numbering in that list.
So that's 1706, and it's all of them, is it? To 1416.
Yes, Commissioner.
And they relate to Mr. Hutson and Mr. Storen.
That's so, Commissioner.
Yes, they're exhibits with that numbering. Thank you.
Thank you, Commissioner. Commissioner, I call Craig Storen.
Mr. Storen, will you take an oath or an affirmation?
An affirmation, Commissioner.
Right. Would you just stand up for a minute and we'll get that done?
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thanks. Take a seat.
Mr. Storen, would you please tell the Commission your full name?
Craig Andrew Storen.
And you received a notice to give a statement and produce documents from the Commission dated the 20th of October 2022.
That's correct.
And you produced a statement in response to that notice dated the 28th of October 2022.
Yes, that's correct.
And you produced a supplementary statement in response to the notice dated the 25th of November 2022.
Yes, that's correct.
Are the contents of those statements true and correct to the best of your knowledge and belief?
Yes, they are.
Thank you. You commenced working in what was then called the Department of Education in June 1985,
Yes,
initially in financial roles.
yes,
Then from about 2003 to June 2013, you were the Chief Finance Officer in that department.
yes,
You then commenced in November 2014 as General Manager Aged Care Programs in the Department of Human Services.
yes,
And then from October 2016 to 30 April 2017, you held the role of General Manager Strategic Information and Redesign in that department.
yes,
And then from the 1st of May 2017 to 22 December 2019, you held the role of General Manager Customer Compliance Division in that department.
yes,
As at the 7th of August 2017, you reported to Jason McNamara in that role, that last role we just described.
that was August 2017.
Yes, 7 August 2017.
Yes, that's correct.
And as at the 7th of January 2019, you reported to Annette Mussolino, who was then the Deputy Secretary, Integrity and Information Branch of that department.
Integrity and Information Group, it may have been called, but yes.
Okay, thank you. And from the 4th of February 2019, you continue to report to Ms. Mussolino.
Yes,
Thank you. As General Manager, Compliance, in that department, you had some involvement in the department's response to the Ombudsman's investigation in in 2017.
I didn't commence in the Customer Compliance Division role until May 2017. So the department responded to the Ombudsman prior and produced a report in April. But I was involved in responding to the Ombudsman's recommendations in their report, yes.
I see. So you're saying you had no involvement in the Ombudsman's investigation in 2017, prior to the report being completed?
I can't say I had no involvement whatsoever, because in the Strategic Information and Redesign role, which I was in prior to the compliance role, I did provide a supporting data function to the whole department in respect of all the department's data holdings. So I may have assisted with some data contributions for the department's contribution. I don't recall specifically.
Can the witness please be shown document CTH.3004.0002.7726_R, Exhibit 1358? Can we call out, please, the email in the middle of that page? Now, Mr. Storen, can you see that purports to be an email from someone called Zahn Smith?
That's correct?
Dated the 14th of February 2017,
That's correct.
to yourself?
No, that's actually to Craig Kelly, who worked for me at the time, but it wasn't directed to me.
I see. Sorry, I missed that. Now, if we just call out the first few words in that sentence, in that email, as per below, to respond to the Ombudsman's outstanding question. That is in the email we're just discussing.
Sorry, could you repeat?
So you can see there the words in that email commence with, "Hi Craig, as per below, to respond to the Ombudsman's outstanding question." You see that?
Correct, yes.
And in round brackets and inverted commas, the question is identified: how many recipients subject to OCI have had their final outcome based on averaging?
Yes.
We have used the debt breakdown by earnings recorded data. See that?
Yes.
Thank you. And if we just call out the same email, the section headed outcome, commences with, as at 27 January 2017, 133,891 debts have been raised. See that?
Yes.
We are unable to identify whether 1,739 debts of those debts are averaged. You see that?
Yes.
And then the next line, so the next bullet point, purports to give a percentage of debts based on averaging out of the remaining 132,152 debts. See that?
Yes.
And the percentage is 76%.
Yes.
See that? All right, then if we go to the email immediately above that, and this is an email to yourself from the other Craig, dated the 14th of February 2017.
It's the other way around, Commissioner. It's from Mr. Storen
From
to
Mr. Storen to
Craig.
Mr. Kelly. Yep.
Oh, sorry, I've skipped over an email, I beg your pardon. So there's actually two emails in that section that's called out. So it should be that section there, thank you. From Craig Kelly to yourself, dated the 14th of February 2017, you see that?
Yes.
It says, Craig, please see our below proposed response for Jason and Alison. Regarding a question from the Ombudsman, let me know if you're okay for us to proceed and we'll send through.
Yes.
Who would be Jason in this
It would be Jason McNamara.
and who would be Alison?
It would be Alison McCann.
Okay. And that, you'd understand, that proposed response would be as per that below email from Mr. Smith we just discussed.
It would be Ms. Smith, but yes.
Oh, thank you. That is that, as at that date, it was estimated that about 76% of debts had been raised using the averaging in the online compliance intervention.
To the best of the ability of the data scientists that were looking at the data at the time, it's one of the challenges during that period was there was no field in the database that said, yes, this debt was determined by averaging. So the data scientists that were working for me were doing the best they could with the data available to come up with that.
What methodology would they have used?
My recollection is they would have looked at how the debt was determined and looked for an even apportionment of income and made the assumption that an even apportionment of income could occur from two ways. One could be averaging or apportionment or whatever you want to call it, or a customer could actually say my income was even and therefore, and there was no field in the information data to actually sift that through. So they've basically based the data on what the numbers look like and looking for even number patterns to make an assumption there was averaging.
When you say even a portion of income, do you mean that the calculations for these social security recipients of debts were based on an assumption that their income had been earned in the same amount per fortnight? Is that right?
That's correct.
And so to come up with this figure, the data scientists in your section were looking for calculations that used even apportionment of income.
I apologise for trying to be so precise, but they were looking for patterns of numbers that led to the calculation of the debt. Yes.
So if you got somebody with $200 every fortnight, you'd assume there'd been apportionment?
That's correct, Commissioner.
Can we just go to the email that comes next at the top of the page? Finally got it right this time, I think. This is the email from yourself to Mr. Kelly
Yes.
in response to the previous email, dated the 14th of February 2017. And the words are okay by me.
Yes.
And may we take it that's you indicating you're okay with the proposed response to the Ombudsman's inquiry?
Yes.
Okay. And then the next text refers to the Data 61 report.
Yes.
What's the Data 61 report?
During that early period in February 2017, after the Robodebt issue had become quite prevalent and widely looked at, the data was looked at quite closely to see if we could figure out what was going on. And it proved that the system that had been built was a transaction system, a system whereby you actually undertake a compliance review. It didn't have any strong, what I would call management information behind it. Data 61 were a private company, I'm not sure of who they relate to, that were data experts that had come in. My recollection is they were called in by the information technology part of the agency to try and pull the data together that was available in the transactional system to see what the data could tell us about what was going on in terms of numbers.
There was a report done, was there?
I recall a paper I've seen in the last week that's been shown to me as a document, and it refers to a report by Data 61. But I don't recall a report, but I have seen a document in the last week that refers to a report.
Right, thank you.
The balance of the email says that the report has 67% of customers did not respond to reviews and therefore incurred an auto-assessed debt. See that?
Yep, yes.
And the concept of customers incurring an auto-assessed debt after not responding to reviews, is that a reference to the process in the online compliance intervention in which customers or social security recipients would receive an initial letter from the department?
Well, they would be sent it.
Sent an initial letter, I beg your pardon, indicating that there's a difference between what had been declared to Centrelink and what had been declared to the Australian Taxation Office in terms of income, and then asked those recipients to go online and update their details. Is that right?
That's my understanding of the process under ICI, yes.
And that if they didn't go online and update their details, the online compliance computer program would automatically calculate their debt, correct?
After the period of time which I think the initial letter advised, yes, that's correct.
And calculate it using income averaging.
That's correct.
And that's the point that you're making here, isn't it? That the data as to the number of customers who had a debt automatically calculated was roughly lining up with what your data scientists were saying from their inquiries about the number of debts that have been calculated using averaging.
Yes.
Now, you were aware, weren't you, that by law, social security entitlement is calculated according to what a recipient's actual fortnightly income is? You're aware of that?
So are you asking in February 2017 when I was responding to this email, was I
Yes.
aware? No.
You weren't aware that the social security law provides that?
No. In February 2017, I was undertaking a role of strategic information and redesign, leading a team of data scientists supporting the whole of the department's data holdings, a few other pieces. I had a supporting role of the compliance function. So no, I wasn't aware of the provisions of the Social Security Act at that time.
And you had, so in your role, it wasn't, sorry, I'll rephrase that, it wasn't part of your role to be informed as to how social security income recipients' entitlements were calculated by law.
Correct, it wasn't a requirement of my role in February 2017.
Okay. That document can be taken down. Can the witness please be shown document ID CTH.1000.001190_R, Exhibit 1713. Now, if we go to the email at the bottom of the second page, please. Email from Julie Ballard. See, that's an email from Julie Ballard to Michael Robinson and Jason McNamara dated the 19th of October 2018.
Yes, I've got the email.
And you can see the words, "Hi Megan, as discussed previously, the Honourable Andrew Wilkie has made comments in the media regarding income data matching and indicated the Ombudsman's Office were investigating the matter." See that?
Yes.
So this is, of course, after the Ombudsman's investigation in April 2017.
Yes, this
See that?
looks like October 2018.
Yep. Refers to previous media releases prepared in relation to this. See that third line?
Yes, yes.
And then it says, the Ombudsman's Office have just sent a letter to the Honourable, it says on, but it means Honourable, Andrew Wilkie and his constituent Mr Dutt, see attached, regarding a number of items that were raised with the Ombudsman's Office. See that?
Yes.
And then you see the next line, to assist the department in preparing for any potential media comments from Andrew Wilkie, the OO, See that?
Yes.
Which is defined in the previous paragraph as Ombudsman's Office. See that?
Yes.
I've sent through their response to both Andrew and the constituent. Please note the content of the letters are not to be distributed widely, and there is to be no reference to the content of the letters in any of the media points releases. Please contact myself for further information as required. See that?
Yes.
And you can see that Julie Ballard is the Director of the Ombudsman Relationship and Management section. See that?
Yes.
You recall Julie Ballard?
The name is familiar.
Did you recall that she worked in the Department of Human Services at this time?
Sorry, could you repeat the
Do you,
question?
do you recall that she worked in the Department of Human Services at this time?
No, I recall the name, and I recall it was a name around my time at Human Services, but other than that. But it's evident she worked in the department as a director.
Okay. We go to the next email just above that and call it out. It's an email from yourself, dated the 24th of October, to Julie Ballard and Michael Robinson. See that?
Yes.
You say, as discussed, I've talked to our office who are looking for something tangible for the Minister to rely on should he be pursued about the recent Wilkie tweet. You see that in the first sentence?
Yes.
And then you see the paragraph, we need to give them something along the lines of. See that?
Yes.
And then there's a quote.
Yes.
And then the next line is, can we get the Ombudsman to sign up to something like that, or can we go further and say they are satisfied with our progress?
Yes.
Do you remember sending this email, Mr. Storen?
No, I don't recall the email.
Okay. Do you agree that one of the things that you, having read this email now and refresh your memory, do you agree that one of the things that you were proposing in this email was that the Ombudsman's agreement be sought as to the terms of a statement from the Ombudsman's office that could be given to the Minister?
Could I just clarify? I don't think the statement is trying to quote the Ombudsman's office, if that's what your question was. I think the statement is trying... So I don't have a clear recollection, but I can have a look at it and try and understand what we were trying to do at the time. I think the statement is trying to have the Ombudsman's office comfortable that we were proposing to say something about their operation in a public way.
Is that, what are the words, can we get the Ombudsman to sign up to something like that mean?
That they would not be uncomfortable if we were to say publicly, sorry, we could be officials in an estimates context, or we could mean the Minister in this context. They would not take umbrage if we said the Commonwealth Ombudsman had looked at what we had, as the sentence says, Commonwealth Ombudsman would not take umbrage if we were to say at estimates, or the Minister was to say they have looked at the progress we've made on looking at their recommendations and trying to respond to their recommendations, is the first point. The second point would be, would they be upset if we said they were satisfied with progress?
Okay, and when you say in the first line, something tangible for the Minister to rely on should he be pursued about the recent Wilkie tweet, is that a reference to something for the Minister to rely upon should he be pursued by a media inquiry about the recent Wilkie tweet?
I'd be making an assumption that it'd be a media inquiry, but that would be a likely scenario.
Okay. We go to the previous page. call out the email from Ms McLeod in the middle of the page. I'm sorry, go to the earlier email at the bottom of the page. Now, you can see that's an email from Mr. Robinson. See that?
Yes, yes,
Dated the 24th of October 2018.
yes,
To Louise McLeod.
yes.
You know who Louise McLeod is?
Off the top of my head, I don't, but I think the previous page that switched up said she may have been the Deputy Commonwealth Ombudsman.
Yes. And you can see the note is Louise, as discussed, see below, referring to the earlier email from yourself to Mr. Robinson. Appreciate your advice.
Yes,
Okay. If we go to the next email up, there's Ms. McLeod's response. Mr. Robinson, dated the 24th of October 2018. And it says, "Hi Michael, can you see the first line? The following has been approved by the Deputy Ombudsman for DHS to provide to the Minister." See that?
yes,
So, and there's a form of words provided. See that?
yes,
And then it ends with kind regards, Louise.
yes,
So would you agree that what Ms McLeod has authorised Mr Robinson to do is to provide the Minister with a form of words for a statement that he can make about the Ombudsman? Accept
Yes.
that? Okay. And to enable him to use that statement to respond to media inquiries?
yes,
That document can be taken down. Can the witness please be shown document CTH.2000.007.5540_R, Exhibit 1640? And call out the email from media at Wednesday, 4 April 2018. So that's before the word's fine with me. And it goes over the page. Now, Mr. Storen, you can see that's an email addressed to a number of persons, including yourself, on the 4th of April 2018. See that?
yep, yes,
And then if we call out the first paragraph and the introductory words of that email. Hi Jason, Robert and Craig. As flagged, we have prepared a response below to an inquiry from the Canberra Times about the online compliance system following the publication of an academic article about the system. Do you see that?
yes,
And it refers in the next paragraph to The Guardian publishing a story about the same article. And then the third paragraph of the statement is, we intend on contacting The Guardian about this and would like to provide them with a copy of the response we have prepared for the Canberra Times. You see that?
yes,
And if we go to the bottom of the page, the inquiry, which goes over to the next page, it opens with, the story I'm writing is looking at a paper attached by Terry Carney AO, which you'd understand to be Order of Australia,
yes,
the Emeritus Professor of Law at Sydney University, about the DHS's online compliance intervention program. Professor Carney makes a number of arguments, including that legal responsibility for obtaining all information necessary for calculating working age payment debts based on verifiable actual fortnightly earnings rather than on the basis of assumed averages ultimately has always rested with Centrelink. You see that?
Yes.
And the next bullet point, the OCI system should be brought into compliance with the law. See that?
Yes.
And the next bullet point, OCI is flawed because statistical averages tell nothing about the variability or otherwise of the underlying numbers from which averages are calculated.
Yes.
Now, this is an email chain as at the 4th of April 2018.
Yes.
And of course, it's making a number of points about the lawfulness of using income averaging to calculate debts to Centrelink. Can you see that?
Yes.
As at the date of this email, were you aware that the Social Security law required entitlements for Social Security to be calculated with actual fortnightly income?
Yes.
Right. And so you, at this stage, appreciate the significance of the criticism of using income averaging to calculate debts that's referred to in this article.
I appreciated the criticism. There was a wide amount of content in the media, including this content in the media about averaging and the process of determining a debt.
And in the context of calculating Social Security entitlements, correct? You appreciated that was of particular significance.
Yes.
And the reason, of course, is that it's frequently the case that recipients of Social Security have income that varies from fortnight to fortnight. You were aware of that, weren't you?
It's common. Yes.
And so that it's a big assumption to make that income averaging will produce an accurate calculation of a recipient's entitlement without some evidence to confirm they have earned income in equal amounts per fortnight.
Could you repeat that? I don't quite agree with some of the words that you're using in the long sentence. I agree with the thrust of what you're saying.
Can I repeat?
Yes.
It's a big assumption to make that income averaging will produce an accurate calculation of a recipient's entitlement without some evidence to confirm they've earned income in equal amounts per fortnight.
Yes.
You agree with that?
Yes.
Okay. And you'd agree that this was one of the fundamental criticisms that was being made in the article from the emeritus professor that's referred to in this media inquiry. Do you
Yes.
agree? Okay. Now, if we go over the page, call out the words headed response. First bullet point says the Department of Human Services strictly adheres to legislation when conducting compliance activities and refutes any claims to the contrary.
Yes.
I should say, you understand this to be the proposed response to the inquiry.
Yes.
And then the next bullet point, the independent review by the Commonwealth Ombudsman found the online compliance system meets all legislative requirements, accurately calculates debts when the required information is entered, and debts raised are consistent with the previous investigation processes. See that?
Yes.
Okay. Now, would you agree with this proposition that it was a standard response at this time by the department to adverse media publicity about the Robodebt scheme to refer to the 2017 Ombudsman report?
Yes.
And in particular to effectively rebut criticisms of the scheme's lawfulness and fairness?
Yes.
Thank you. That document can be taken down. Can the witness please be shown document CTH.3004 1.0009.0076.16, sorry, Exhibit 1649. Mr. Storen, you see that document purports to be a compliance modernisation program management dashboard.
That's correct.
Would you have seen documents like this in your time in the Department of Human Services?
Yes.
And would this be right that these documents were produced at regular intervals by the department to track the compliance modernisation program's progress in terms of meeting the budget targets? Agree with that?
Amongst other things, but yes, the budget targets were an important part of the report.
Okay, can we just call out the top right-hand corner section headed EIC interventions completed FY18 TD? See that?
Yes.
And so would you accept that FY18 would be referring to financial year 2018?
It'll be the 2017-2018 financial year, yes.
And TD would be to date?
Yes.
Okay. And you can see there's a picture that's purporting to depict interventions completed FYTD and has a breakdown represented by the two colours, orange and blue. Do you see that?
Yes.
Okay. And one says online completion 7%. See that?
Yes.
And the other says staff assisted completion 93%.
Yes.
Okay. What does online completion 7% refer to?
My recollection, a fair degree of certainty, is that would be a compliance intervention where the customer who has received the initiation letter has logged online, completed the intervention themselves, so apportioned their income, whatever they needed to do, and then finalised the completion without recourse to a compliance officer.
Okay. And then, so what would then staff assisted completion be referring to?
That would be where so my reading of the document is that would be where a customer has called in to a compliance officer and the compliance officer has worked with that customer over the phone. It may have been over several phone calls, it could have been an exchange of data, but it basically means the compliance officer has completed the intervention.
Okay. And may we take it that what this is representing is that that second category you've just described, 93% of the interventions as at the date of this report for financial year 2018 had been the staff assisted kind.
Yes.
Whereas only 7% had been the online completion kind.
Yes.
Now, the Robodebt scheme was designed, wasn't it, so that the vast majority of recipients were supposed to complete their interventions online, wasn't it?
The original budget measure announced by the government prior to 2017 and the original implementation of OCI, that is correct. The intention was to be a largely technology-driven, customer-driven process.
And that intent was fundamental to the assumptions as to the number of interventions that could be completed as per the budget measure, wasn't it?
The original costings agreed to government prior to 2017, yes.
Right. And what this indicates is that that just was not happening as at the date of this.
So this report is June 2018, so it would be reporting on the progress of EIC, which was the replacement to the OCI system. The EIC implementation was fundamentally different to OCI in that it had the manual handoff to compliance officers as a feature of the business process. So it was expected that there will be a higher number of staff-assisted completions for this time period because it is different from the OCI.
This level of staff-assisted completions?
I couldn't recall. I would say that would be higher than you'd anticipate. But I wouldn't have the original assumptions behind the transfer to EIC, what was assumed to be handled by compliance officers.
Because of course staff-assisted completions is much more resource intensive, isn't it?
It is, yes.
And it's just not possible to complete the number of completions that were contemplated in the original budget measure with this level of staff-assisted completion, with the resources that the department has.
It's not likely, no.
Thank you. That can be taken down. Can the witness please be shown document CTH.2000.0010.7660, Exhibit 1725? Can we call out the email at the bottom of the screen from Mr. French? Now, Mr. Storen, you can see that's an email from Mr. French to yourself dated the 18th of February 2019.
Yes.
What role were you in at the time of this email?
I'm likely to have been the General Manager of Customer Compliance Division.
Okay. And you see the subject line is Masterton Federal Court application.
Yes.
You remember the Masterton litigation?
Yes.
You see the first line addressed to you, thanks you for your time in the teleconference that afternoon.
Yes.
And it notes that, as discussed, legal services have engaged the Australian Government solicitor to represent the Secretary.
Yes.
And that is in response to the proceedings brought by Ms Masterton.
Yes.
You see the second paragraph in that email, the words, legal services will urgently seek advice from AGS in relation to whether the debt owed by Ms Masterton should be recalculated using information regarding employment and income obtained pursuant to the Commonwealth's information gathering powers rather than by any method using income averaging. You see that?
Yes.
And the use of the Commonwealth's information gathering powers, do you recall what that's a reference to?
I can't quote the legislation, but there are legal provisions allowing the department to, in a practical sense, right to employers to gather pay data on individual customers.
And so instead of relying on income averaging to calculate entitlements, look for evidence from employers as to what actual earnings were derived by the recipients. Is that right?
Correct.
Why was it in contemplation at that time that Miss Masterton's entitlements might be recalculated using those information gathering powers?
I can't, well, I can't recollect, I can't be sure. The assumption, potentially the legal position from the lawyers was that averaging wasn't appropriate in Ms Masterton's case.
You recall up to that point in time ever receiving legal advice that in some cases income averaging was appropriate, but in others it wasn't for particular social security recipients?
No.
It was the position, wasn't it, up to that point in time of the department that income averaging was a perfectly lawful method for calculating social security entitlements?
Correct.
And so there would be no reason why, in response to this litigation, if the department maintained that position, to recalculate her entitlements by reference to means other than income averaging.
Sorry, I missed the first proposition.
There would be no reason why the department would see a need to recalculate Ms Masterton's entitlements by means other than income averaging, given its position, was perfectly
Correct.
lawful.
Yes.
Do you recall prior to this time cases in the AAT, that is the Administrative Appeals Tribunal, leading to decisions by the department to recalculate entitlements of social security recipients without the use of income averaging?
I was aware of some, yes.
And that is in circumstances where you recall there were 2 tiers of AAT reviews,
Yes.
and tier 1 was the first tier, and that is the first stage in the process of appeal.
Yes.
And if either the department or the income recipient was unhappy with the outcome, they could appeal to the next stage, to tier 2.
Yes.
If they were still unhappy, there might be some avenue to appeal to the federal court.
Yes.
Okay. And so you recall some instances, do you, where there were AAT cases where income recipients challenged the use of, social security recipients, I should say, challenged the use of income averaging to calculate their entitlements?
I couldn't say I recall the specific reference to income averaging. I do recall there were cases that were returned from the AAT for the department to access employer data.
Right, and by that you mean the AAT had found at tier 1 that income averaging was not a proper basis to calculate social security entitlements.
By implication, yes.
And do you recall any occasion when that occurred of the department appealing those determinations to the next tier of the AAT?
No.
Why not?
I may not have. So in an organisational sense, the conduct of the appeals process, the authorised review officers and AAT1 was overseen by a different division in the department, by the Information Debt and Appeals Division, and AAT2, the higher tier, was overseen by the Legal Services Division of the department. So I didn't get to see a lot of detail about what was going backwards and forwards through those places. But when a compliance case needed to be re-looked at, it would have flowed through to compliance officers that I was responsible for. So I was aware that it was happening. I couldn't give you a sense of volume or detail.
So you're aware it was happening in the sense of instances where matters were being returned by the AAT at tier 1?
Yes.
And the re-looking was the reconsidering of the debts by your part of the department?
Yes. The reason I'm struggling is there would have been other returns for other reasons as well, and I didn't have visibility of drilling into all the reasons things were being re-looked at.
Well, I'm just asking about the instances where they're returned because of the use of income averaging.
And I don't recall any specific instances, but I have a general awareness there was activity going on.
Were you involved in any of the decisions recalculating debts following the return of matters by the Tier 1 AAT reviews because of the use of income averaging?
Not that I'm aware of.
Are you aware of the reasons of any of those? Were you made aware of the reasons for any of those decisions?
I was aware by early 2019 of the dissatisfaction with income averaging. Yes.
Not before then?
I may have been, I mean, I have a recollection during the course of 2018, it surfaced every now and again, but I don't have a clear recollection.
So at that point in time that you're describing, in late 2018 and early 2019, it was still the position of the department that income averaging was a perfectly lawful means of calculating social security entitlements.
Yes.
And decisions are being returned by the AAT first tier because income averaging is being used. Correct?
I was generally aware that there were some, but I can't give you a sense of value.
And the consequence, wasn't it, that unless the department appealed those decisions, it would have to abide by them, correct?
That's my understanding, yes.
And it's right, isn't it, that the department did abide by them, correct?
I didn't have a lot of visibility into the appeals and returned appeals through a business process sense, but my assumption would be yes, the department would have abided by them.
Unless they appealed, it would be extraordinary, wouldn't it?
The conduct of the appeals process and so forth wasn't within the area that I was in charge of. It was another function. I was aware of the operation of it, but not of the detail.
But in terms of you being in charge of the area that's making these decisions that are coming back, you would be concerned if the decision makers weren't abiding by the decisions of the AAT, wouldn't you?
Yes.
And so you would expect that they would be abiding by the decisions of the AAT unless those decisions were appealed. Correct?
Yes.
So given that the department had the position that income averaging was perfectly lawful as a means of calculating debts, do you have any knowledge of why the department was not appealing the decisions by the AAT to the effect that that means of calculating debts was unlawful?
No.
You had no conversations with those in the department responsible for the decisions, whether to appeal those decisions? About
I don't have any recollection. No.
who would have knowledge of those matters?
I think, as I previously said, the appeals function was managed by the Information Debt and Appeals Division, which was another division within the group in which I worked. It reported to the same deputy, and the appeals AAT2 function was managed by the legal division, whatever title it was at the time.
Can you give us some names?
So Information Debt and Appeals, I think my witness statement says that Karen Harfield was the general manager of that.
At this time?
Early 2018, that's 2019. Likely to be. at that time, reporting to the same deputy as I reported to, and Legal Services Division was probably Tim French, who's on that email.
So Tim French and Karen Harfield.
Tim French managed the legal services function for the entire department, and Karen Harfield managed the appeals function.
And is she the person who would have been giving instructions to Mr French as to whether or not to appeal these decisions, is that right?
I don't know what the business arrangement relationship, how those matters were dealt with, no. But if the department was to mount a legal position, that would have to be undertaken by the legal services part of the department.
That can be taken down. The witness please be shown document CTH.2001.0012.991, exhibit 1728. Sorry, I should have showed you an earlier document. The document is CTH.2001.0012.9989, exhibit 1727. Do you see that's an email from Mr French to Ms Mussolino and to yourself?
Yes.
Date of the 5th of March 2019.
Yes.
This time, do you recall what role Ms Mussolino had in the department?
I'm basing my assumption on the CC on the same email, copies it to the Deputy Secretary I&I, which would be Ms Mussolino is likely to have been the Deputy Secretary of Integrity and Information at the time. And Mr French looks like he would have been the Chief Counsel, so in charge of the Legal Services Division at the time.
Okay. Now, this is dated the 5th of March 2019 and it refers to an AGS advice. You see that?
Yes.
As an attachment. And I just call out, so first of all, it's addressed to yourself and Ms Mussolino, you see that?
Yes.
You think why it would have been you that was receiving this email?
Because any recalculation would have been undertaken by compliance officers that worked for me.
Could we call out, please, the words, the bullet points under the heading for the purposes of the conference, we request the following instructions. You see the first bullet point asks whether to proceed to recalculate the debt without using averaged income from ATO records in accordance with AGS advice. This recalculation would potentially include the use of compulsory powers should Ms Muston not provide further information. So it says the basis for the recommendation is outlined further below. Do you see that?
Yes.
Okay. And if we call out the words under the heading debt recalculation, including up to the section on the next page just before the words, the heading in interlocutory injunctions. Now, do you see two options are proposed? And they're both involving recalculating the debt.
Yes.
Option one is to not option 1 is to use a similar process of income averaging. See that?
Yes.
And option 2 is to recalculate the debt without income averaging. Do you see that?
Yes.
Do you see in the last sentence of the description of option 1, these words, if Ms Masterton declines to provide any further information, this recalculation would still be based on averaging of income from ATO records. If this were to occur, proceedings would likely continue. Do you see those?
Yes.
And you see the words below the two proposed options, the words AGS is of the view that option 2 is the preferred option, as it is likely to lead to finalisation of the present proceeding.
Yes.
And you'd appreciate that if the proceeding was ended as a result of that option, there wouldn't be a determination of the lawfulness of income averaging in the proceeding.
I can appreciate that from the words in the email, yes.
Okay. All right. Now, if we go to the attachment, which is CTH.2001.0012.991, Exhibit 1728. This is the attached advice that's referred to in the previous email, Mr. Storen. You see at the top, the top email is, well, it purports to be have the words Matthew Rosa at the top, but you can see below that who sent the email that appears towards the top of the screen, Mr. Ensby. Do you see that? And it's addressed to Mr. Rosa.
Yes.
It's dated the 5th of March. And you can see, if we scroll down and call out the words under the heading option 1, you can see the first option is to recalculate the debt using a similar process of averaging that was used in the original OCI calculation. See that?
Yes.
And you see the words at the end of the last paragraph called out. In this event, we anticipate that Ms Masterton would likely seek to challenge the legality of any debt raised after this recalculation based substantially the same grounds as in her existing application. Do you see that?
Yes.
And then if we go call out the words under the heading option 2, which go over to the next page. It says the second option is to recalculate the debt without using averaged income from ATO records and instead conducting the fullest investigation reasonably possible into Miss Masterton's income over the relevant period. You see those words?
Yes.
You can see there's a clear distinction in the two options between using averaging and not using averaging in the recalculation of the debt.
Yes.
And just context, it's the case, isn't it, that by this stage of the proceedings it had been identified there was an error in the calculation of the debt in any event, and the department needed to recalculate the debt.
Yes.
Okay.
From the email traffic, there was looks like a duplicate record and a calculation error.
So the question was how it was to be recalculated,
Yes.
whether or not averaging was to be used or not.
Yes.
And option 2 would not use averaging of income, correct?
Yes.
We call out the paragraph under the heading observations on the preferred options. It says, we consider that option 2 is very likely to be the department's preferred approach, as it is likely to end the present federal court proceeding The only scenario in which option 1 appears to us to be more attractive is if the department had a positive desire to have the federal court issue a ruling on the legality of the use of averaging and or the OCI system. We do not understand this to be the case. We agree that those words are indicating that it was not the department's desire to have the federal court issue a ruling on the legality of the use of income averaging.
Yes.
You have a memory that that was the case.
I don't have a specific memory that that was the case. I recall the profusion of emails around the legal cases. That doesn't surprise me that that was the inclination at the time.
Or do you have a general recollection that members of the department expressed to you a lack of desire for the federal court to issue a ruling on the legality of the use of income averaging?
I don't have a clear recollection, no.
Can you assist the Commission at all as to why it would be the case that the department would not want a ruling from the federal court on the legality of income averaging?
I don't think I can. The department's position at the time, which you've stated, was that the use of income averaging was still a valid approach to determining customers' income over a period of time to determine whether they had the correct amount of income support. And that was the accepted department position at the time.
Well, if they were confident about that, why not proceed on that basis in the federal court?
It's not a matter to which I was asked my opinion at the time on what we should do, and I don't think I was in a position to offer a legally sound view.
That document can be taken down. And the witness please be shown document CTH.2001.0013.3098, Exhibit 1731. Just call out the email at the bottom of the page. See, that's an email from Mr. Ensby again, dated the 27th of March 2019.
Yes.
Thank you. And it's addressed to Mr. Rose and Mr. French.
Yes.
And it refers to attached draft advice on prospects.
Yes.
And the subject is in relation to Masterton.
Yes.
Okay. We go up to the email at the top of the page. See, it's an email from Mr. French to Ms. Mussolino, CCing yourself and Mr. Rosa. See that?
Yes.
There's a draft advice on prospects in Masterton is attached. The advice is lengthy and I have yet to read it in full. The critical advice is in relation to Q3 regarding a recalculated debt removing double counting but conducted on the basis of apportionment.
Yes.
You of course understand that to refer to income averaging.
Yes.
AGS considered that Miss Masterton has good prospects of succeeding in a claim for relief on the basis that the use of apportioned ATO PAYG data will not establish that she owed a debt under section 1223, subsection 1. See that?
Yes.
Okay. Might the witness please be shown document CTH.2001.0013.311, sorry, .3100, exhibit 1732. Thank you. You recognise this document, Mr. Storen?
I recognise the header and so forth, but not the document itself.
Okay, well, I'll take you through it. See, it's dated the 27th of March 2019.
Yes?
It has AGS header on it. See that?
Yep. Yes?
Addressed to Mr. Rosa. See that?
Yes?
Marked draft. See that?
Yes?
And then if we call out the section headed "Your questions and our short answers." I note particularly A2 at the bottom. The applicant presently has very good prospects of succeeding in the claim on the basis that the second alleged debt contains calculation errors. See that?
Yes?
And if we go over the next page, first bullet point, one of the errors is identified. The top of the page, portioned ATO PAYG data does not establish that the applicant owes a debt under section 1223 subsection 1. See that?
Yes?
And if we look at A3, in the middle of the page, the applicant would have good prospects of succeeding in a claim for relief on the basis that the use of apportioned ATO PAYG data will not establish that she owed a debt under section 1223 subsection 1. You see that?
Yes?
Okay. If we go to the section background at the bottom of page 3, starts there. See paragraph 6. In July 2016, the Department of Human Services launched a semi-automated online compliance system.
Yes?
That, of course, is Robodebt, isn't it?
Yes?
And then if we look at paragraph 7, which goes over the page, first major premise of the system is the automatic matching of employer-reported income data obtained from the ATO with data held by Centrelink about a customer's reported earnings. Through the matching process, discrepancies which may give rise to a debt are identified. The second major premise of the system is that in circumstances where a customer does not engage with the compliance process or does not provide all requested information, a compliance officer may and generally will apportion the PAYG data to produce a daily and fortnightly income amount for the customer over the relevant period, known as an apportionment. See that?
Yes?
This is, of course, referenced income averaging.
Yes?
And then you can see in paragraphs 8 and 9 a reference to the circumstances of the applicant in the Masterton case, Miss Masterton.
Yes?
And then if we go to page 7, para 18, there's a reference to acknowledged errors in the calculation of the debts. See that?
Yes?
And then in para 21, there's a description of what would occur if the first debt was still operative. But then an acknowledgement that's now been overtaken by the second debt. So that's the only debt under consideration.
Yes?
And then in the next paragraph that goes over the page, there's an indication that the applicant is likely to pursue proceedings given the second debt still operative. See that?
Yes?
And then paragraphs 23 and 24, is an acknowledgement that apportionment was used to calculate the debts, and that the AGS view is that the applicant has good prospects.
Yes.
Then if we go to page 10, and call out on pages 10 and 11 the passages in paragraphs 36 to 42. Just read those passages to yourself without reading them aloud, please.
Yes, read through it.
And in particular, para 42 says there is no statutory basis in the SSA, which is of course a reference to the Social Security Act, correct?
Yep.
No,
Yes.
no statutory basis in the SSA or related legislation for deeming apportioned fortnightly income to be accurate or provide a sufficient basis on which to raise and pursue a debt. See that?
Yes.
Right. And have you seen enough of this document to recognise what it is now?
Yes.
This is the draft advice that was attached to the email I showed you just
Yes.
before. Thank you. This is the draft advice from the AGS about the Masterton case, correct?
Yes.
This is advice received by you on the 27th of March 2019.
CC to me on that day, yes.
Yes. Do you recall reading that advice?
I don't recall the whole specific advice. I do recall various elements of it. Whether it was from that advice or other pieces, I couldn't be certain.
The advice clearly indicates that income averaging to calculate social security entitlements is unlawful, doesn't it?
It's saying there's no statutory basis.
Which means it's unlawful.
In the context of the Masterton facts is my understanding of what the advice was provided for.
Are you saying that you understood this advice was limited to the circumstances of Miss Masterton's case?
My understanding of, my recollection of conversations at the time was that the advice was related to the circumstances of the Masterton case.
What conversations are you referring to?
I would have had conversations with Mr. French and Ms. Mussolini at the time, deferring to them for matters of legal advice, as that's not my area of expertise. Hence this was copied to me rather than sent to me.
Are you saying that they said that the effect of this advice was limited to the circumstances of Miss Masterton's case?
My recollection of general conversations at the time was the advice was around the Masterton case itself.
And was not a comment on the lawfulness of income average in general?
That's my understanding at the time.
So when it said there's no statutory basis for averaging, you thought that was, there's no statutory basis in relation to Ms Masterton, but for everybody else it's fine.
I don't recall reading that specific paragraph, but my general understanding at the time was that the way the legal position on the Masterton case was related to the facts of the Masterton case.
The witness please be shown paragraph 65 on page 15 of the document. See, it says the scope of our advice is confined to the prospects of the applicant succeeding in a claim in the federal court. See that?
Yes?
You see the next words, we are conscious that the conclusion we have reached about the use of proportion data where a person has inconsistent income like the applicant has broader implications. And then the recommendation is made about seeking further advice.
Yes.
You remember reading this passage?
I don't remember reading this passage, but I do recall that there was a process kicked off, whether it was a process commenced to seek wider advice on the overall legal position of apportionment.
So just to be clear, are you saying that this advice did not lead you to the realisation that use of income averaging to calculate social security entitlements was unlawful?
The advice wasn't sent to me, I was copied it. I was aware of the general thrust of the advice, whether from reading the advice in toto itself or not, I can't tell you. And I was aware that there was then processes in place to seek a firmer Commonwealth position on the legality of apportionment.
Was Mr. Masterton's entitlements recalculated using income averaging following this advice?
I don't recall. Based on the previous email she showed me where the recommendation was to seek information from employers, I'm sorry, my brain blurs between the Masterton Amato and then the class action with a whole wide range of legal things that occurred during that period. So I can't tell you for certain what action we undertook.
Can you think of a reason why the Commonwealth would recalculate her entitlements without using income averaging if it did not accept the position stated in this advice that income averaging is unlawful?
I can only assume that the direction was to seek a broader view about income averaging whilst recalculating Ms Masterton's advice using an alternative method.
Is that a convenient time for the morning break, Mr Scott?
I have about 5 minutes left with the witness.
Oh, okay.
Could the witness please be
Commissioner,
shown?
just to assist Mr Scott, I do need to raise a number of matters with him, which may mean the witness either needs to...
Sorry, in relation to Mr Storen?
Yes.
Perhaps you'd better take the morning break. We will come back at 2:45. Thank you.
All rise. The Commission stands adjourned until 11:45. The Royal Commission is now in session. Please be seated.
Yes, Mr Scott.
Commissioner. Might the witness please be shown document CTH.3004.0012.1695_R, Exhibit 1721. You see that document, Mr. Storen?
Yes.
You see it purports to be an email from yourself to Cherie Harrison.
Yes.
It's dated the 10th of April 2019.
Yes.
Purports to have a document attached to it called document 1.docx. See that?
I can see the attachment reference, yes.
Yeah. Who's Cherie Harrison?
She, at that time, she would have been one of my national managers, a direct report to me.
Okay. See the words too much for PM&C?
Yes.
PM&C, of course, is the Department of Premier and Cabinet.
Prime Minister and Cabinet.
Sorry.
Yes.
Prime Minister and Cabinet, beg your pardon.
You've been doing too much state work,
Yes, Commissioner.
Mr Scott.
Could the witness please be shown document CTH.3004.0012.1696, Exhibit 1722. This is the attachment to that email we just discussed, Mr. Storen. See the words under the heading background, Miss Masterton commenced action in the Federal Court of Australia on 4 February 2019 with respect to a debt.
Yes.
And Miss Masterton asserts that the department's use of income averaging based on income data obtained from the Australian Taxation Office does not provide a lawful basis upon which the department can raise a debt. See that?
Yes.
You recall that the email that this is attached to is dated the 10th of April 2019.
Yes.
Recalling that the draft advice from AGS about the Masterton proceedings was dated the 27th of March 2019. You recall that?
Yes.
And then if we go further down the page, the words in the fourth last paragraph on 12 April 2019, the department will finalise the review of the debt and advise Ms Masterton through her lawyers accordingly. This is expected to cause media coverage. The department's media talking points are attached.
Yes.
And then the next two paragraphs. It is unknown whether this approach will finalise the matter for Ms Masterton or whether another complainant will be identified by Victorian Legal Aid to continue the challenge.
Yes.
And the next words are the question of providing specific legislative direction to authorise income averaging may need to be considered in the future.
Yes.
Do you see that?
Yes.
Do you remember preparing this document?
No.
No memory of it?
No. As I said previously, from the Masterton to Amato to the class action is a blur of legal documents and briefings in my recollection. So I don't recall this specific document.
Do you ever recall preparing a document around April 2019 raising the question of providing specific legislative direction to authorise income averaging may need to be considered in the future?
No, I don't recall it. I'm not surprised by the document, and given the header email, it looks like PM&C were after a quick one-pager explaining the situation with the Masterton case. which appears to be what I've put together, is the simplest explanation that I could with the information I had of the case and where it was at. So no, I don't recall this preparing a specific document, but nothing in there is a surprise to me having prepared. Sorry if that doesn't make sense, but
Can you assist us at all as to what the words "too much for PM&C" might mean?
my assumption is I was just seeking one of my ways of working to produce material quickly would be, rather than delegating the work and then working on a colleague's work, I would actually draft a very quick draft myself, then give it to a trusted colleague to turn into a more complete product. That's likely what that is just my brain dump to get a draft of some information to provide PM&C, who must have asked for a status report of the case.
Can you assist us, though, what the words "too much for PM&C" mean?
My apologies. I was asking Cherie, have I put too much detail in here for PM&C?
I see. You have a recollection whether you, in the event at about this time, provided a document of this nature to PM&C?
I don't recall. My assumption is a more polished version of this is likely to have gone to PM&C, but I don't recall.
Including the reference, the question of providing specific legislative direction to authorise income averaging may need to be considered in the future.
I don't recall what the final document may have been.
Okay. Those are your words. The question of providing specific legislative direction to authorise income averaging may need to be considered in the future.
I don't recall typing those words. The use of that language feels like it could have been me, but I don't recall writing those words. It's the type of assumption I possibly would have made from the previous series of documents that you showed me around the broader question.
You accept that, given this is attached to an email from yourself, that it's likely that those are your words?
Yes.
Do you accept that those words which you inserted into this document are a reflection of your then knowledge that the use of income averaging to calculate social security entitlements, then gained from the AGS advice we've just been discussing, was unlawful?
I would phrase it as needed further legal clarification.
What further legal clarification was needed?
So my understanding of the legal advice that we looked at earlier was in relation to the Masterton case, and a complete legal position was required for the department to understand its position.
The advice explicitly acknowledged that it had broader implications, didn't it?
There could be broader implications, yes.
And that the advice explicitly stated that the use of income apportionment, i.e. income averaging, was not a lawful basis to calculate a debt.
Yes.
And did not state that only was the case for Mr. Masterton, did it?
My understanding is the legal advice was provided in the context of the Masterton case, but it brought into question the use of apportionment more broadly. Yes.
Yes, because it was commenting on the provisions of the social security legislation that didn't just apply in the Masterton case, they apply to social security recipients generally.
More generally, yes.
And so it was clearly not limited in its application to the Masterton case, was it?
By implication, no.
And so your then knowledge, after having been informed of that advice, and as reflected in this document, attached to an email dated 10 April 2019, was that the use of income averaging to calculate social security entitlements was unlawful.
So the advice was in the context of the Masterton case, and my understanding at the time was the Commonwealth needed to consider its position more broadly.
Why would it need to consider its position more broadly?
I can't tell you that. I don't understand. I don't understand why that position was taken. My role at the time was delivering a function in accordance with the government's policy at the time. There were questions being raised, as you pointed out, and the Commonwealth was yet to determine its position on where it wanted to take the delivery of the program.
Commissioner, that's the evidence of this witness.
Ms Hogan-Doran?
No, Commissioner, nothing.
Can Mr Storen be excused?
You can.
Yeah, thanks, Mr Storen. You're excused.
Commissioner, I call Jonathan Hutson.
Commissioner, just while Mr Hutson is coming in, I just raised a matter, just a housekeeping matter with council assisting. In today's exhibit list, there are a number of documents which are identified as documents referred to in the statement of Mr Storen, and that included the documents he was just taken to, which are exhibits 1721 and 1722. Those are actually additional documents. They're not referred to in his statement. We'll have that clarified so that the position is clear as to what he had an opportunity to review before and what he hadn't.
Okay, and you've put that on the records?
We will, thank you.
Thank you. Yes, Mr Hutson, will you take an oath or an affirmation?
An affirmation, Commissioner.
All right, could you just stand for a moment?
Thank you.
Your response is, I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thanks. Take a seat again. Thanks very much. Yes.
Thank you, Commissioner. Mr Hutson, would you please tell the Commission your full name?
Jonathan Hutson.
And you've received a notice from the Commission to give a statement and produce documents dated the 27th of October 2022?
I have.
And in response to that notice, you produced a statement dated the 2nd of November 2022?
Yes.
And a supplementary statement dated the 3rd of December 2022?
Yes.
The contents of those statements true and correct to the best of your knowledge and belief?
They are.
Thank you. It's the case, isn't it, that you were the Deputy Secretary Enabling Services from sometime in the second half of 2013 to 11 September 2017?
That's correct.
Okay. The witness please be shown CTH.3502.0001.0236, Exhibit 1685. Will be brought up on the screen.
Sure.
Now, can you see, Mr. Hutson, that purports to be a senior executive structure for the Department of Human Services. And you can see on the top right-hand corner, we call that out, the effective date of it is the 9th of January 2017.
Yes.
Okay. And you can see, if we bring that down, you can see top left-hand corner, the secretary is identified as Catherine Campbell.
Yes.
And then if we call out the, I think it's pink section in the middle, or red.
Mhm.
See the enabling services division is identified.
Yes, it was a group.
Oh, sorry, group.
Mhm.
And you're identified as its deputy secretary.
Correct.
And reporting to you, among a number of people, was the head of legal services, Annette Mussolino.
That's correct.
She was chief corporate counsel.
Chief General Counsel, I think, was her official title.
That can be taken down. Now, from 11 September 2017, you were appointed to the role of Deputy Secretary for Shared Services for the department,
That's correct.
and you retired in July 2018. Is that
That's
right?
correct.
Okay. Can we just bring up page 3 of your statement, paragraphs 11 to 13? Supplementary statement, that should be. That's doc ID JHU.999.0001.0027_R. Right. You recognise those passages from your supplementary statement?
I do.
And those passages describe the extent to which you viewed the evidence of hearing block 1 of this Royal Commission.
Yes.
And can you just describe what parts of the evidence you watched?
I do remember very clearly watching Mr. Gregory's opening statement, which I refer to elsewhere in my submission because it provided me with some interesting and new information. I then followed on and I watched on that first day, I do remember Ms. Masterson's evidence. I think on that first day there was some of Ms. Pulford's evidence, but I didn't watch all of that. Tuesday and Wednesday, I was pretty much organised, I think, with producing my first statement. And I would have watched other bits of evidence during the next day and a bit. I do recall in the last 3 days, I think it was, of hearing block 1, I watched quite a lot of it. I was watching it while I was reviewing documents at the Attorney General's office, Attorney General's Department. I did mention that I saw most of the evidence of Mr. Britton and Ms. Ryman. I watched the evidence of Ms. Campbell, Mr. Pratt and Ms. Wilson.
You watched some of the evidence from the premises of the Attorney General's Department?
Yes, that's correct.
And was the live stream of the evidence on in those premises?
I was interested in watching the hearings, and I took my iPad with me to the Attorney General's Department, and I asked for permission to connect my iPad to the department's Wi-Fi so that I could watch the hearings.
Did anyone there see you watching the hearings?
Yes, officers of the Attorney General's Department were with me continuously for the 3 days.
Lawyers?
I believe so, yes. I don't know the exact qualifications of the people who were present.
Did they advise you that you should not watch the evidence?
I have no recollection of them advising me not to watch the evidence.
You refer in paragraph 11 of your supplementary statement that you were advised on the 26th of November 2022
Yes,
by a senior lawyer of AGS to not watch any of the proceedings.
that's correct.
Is that the first time you were told not to watch any of the proceedings?
To my recollection, that's correct.
And have you watched any of the proceedings since?
No.
You, that can be taken down. Can the witness please be shown document CTH.3001.0034.0729_R, Exhibit 1738. If we can go, please, to the bottom of the second page of the document. You can see towards the bottom of the page, purports to be an email from media to media and others whose details have been redacted. Is media just a descriptor for a generic email address for the media unit within the department?
Yes.
And date of the email is the 21st of January 2017. See that?
Yes.
Subject is the weekend top stories. See that?
Yes.
And you can see that it says, please find below today's Department of Human Services top stories. See that?
Yes.
Do you recall whether the media unit had a regular email circulating within the department about the day's top media stories concerning the department each day?
Yes.
Okay. And would this be one of those regular emails?
Yes.
Okay. And if we scroll down, you can see, for example, a reference to a story from the Hobart Mercury, a reference to Blair Richards, Tasmania's Human Services Minister, calling for a halt to the Centrelink debt recovery scheme. Do you recall? See that?
Yes.
And then at the bottom, there's a reference to a story on ABC Online reporting Tasmania's Liberal government wants the Commonwealth to delay the expansion of Centrelink's troubled debt recovery program.
Yes.
If we go over the next page, there's a story towards the top of that page referring to Slater and Gordon lawyers investigating if Centrelink debt system breaches law,
Yes.
being reported in Guardian Australia.
Mm-hmm.
And then there's further stories in the email. Would you agree with me that a number of these stories are referring to the Robodebt scheme as it was then in implementation?
Yes.
And is that consistent with your recollection of the time that there was a substantial amount of adverse media publicity about the program?
Yes.
Okay. If we could then go to the next email up towards the top of the second page. Pull that out. It's an email from Melissa Golightly. She was at the time Deputy Secretary for Integrity and Information.
Yes?
So neither you nor her reported to each other.
No,
You're effectively equals within the department,
that's correct.
at Deputy Secretary level.
Yes.
And the email's addressed to yourself and Annette Mussolino.
Yes?
And the email commences, "Hi Jonathan and Annette, read the article in The Guardian below and the mention of Slater and Gordon." See that?
Yes?
That's clearly a reference to the summary of the article in The Guardian about Slater and Gordon investigating if Centrelink debt system breaches the law that we've just discussed earlier, isn't it?
Yes.
And Centrelink debt system, that's referring to Robodebt, isn't it?
Yes.
Now, the next paragraph. Given we haven't changed the way we do the data matching or the way we assess or calculate the debts, i.e. we are doing it the same way we have done it for many years, does this form the kernel of any immediate legal advice we may need to give? This has been our position to date when other mentions of legal issues have come up in the press. Is there something you need from my people to give you, show you, to help you with this? Do you see that?
Yes.
And in particular, the words, "we are doing it the same way we've done it for many years." Do you see that?
Yes.
Do you recall that was a consistent message used by the department in responding to criticisms of the Robodebt scheme as to its fairness and lawfulness? That is, it was being done in the same way that debts had been raised for many years.
Yes.
In fact, it was a constant refrain.
Yes.
Now, what I'm interested in is the last paragraph in that email. Not sure we need formal external legal advice just yet, unless you have a different view. Just want to be ready with something but not scare the horses. We don't want to give the impression we are concerned when we are not. See that?
Hmm?
What did you understand? First of all, do you recall receiving this advice? Email, I should say.
Yes. I've discovered it in my document review, but I also have some recollection of this from my memory.
You have a recollection of understanding what the phrase "not scare the horses" meant?
I don't have a contemporaneous recollection of what that meant at that time.
Is that a phrase Ms. Golightly frequently used?
Not that I recall.
Do you have an understanding now of what it's
I am assuming that what it means is that she had a concern that if we do something like seek formal external legal advice, which is mentioned in her first paragraph, that may give some people the view that we were not as certain about our position as we were. But then she goes on in her third sentence to say we don't want to give the impression that we are concerned when we are not.
By external legal advice, would that be referring to, for example, external legal advice from AGS?
It would mean external legal advice from outside the department.
Which might include
Might include AGS, but it could include other lawyers as well.
Could include a private firm?
It could.
Could include a barrister?
Potentially, yes, but we would need a law firm, firm of solicitors to instruct a barrister first.
Of course. But the form in which the advice might be given is an advice from a barrister on instruction from external lawyers.
Indeed.
And one possibility, of course, would be advice from the Solicitor General.
That would be one option, yes.
Now, this was a program that was supposed to be saving the Commonwealth billions of dollars
That's correct.
over the course of its entire life,
Yes.
as announced in the 2015-16 budget.
Yes.
So it would surely have been quite important to the department to get a definitive legal view, wouldn't it?
I would have thought so.
And if a definitive legal view were obtained, then how could it be that there would be caused a lack of confidence in the program if the definitive legal view was that the program was lawful?
I'm sorry, I don't quite understand your question.
Just in reference to the comment about not scaring the horses
Yes?
and the concern that if legal advice, external legal advice is sought,
Yes?
that it might project a lack of confidence in the program.
That's correct, yes.
Yes. But once a definitive legal advice was obtained, and assuming that legal advice confirmed the lawfulness of the program, then surely that would have the opposite effect. That is, it wouldn't project a lack of confidence in the program.
Your point is well made. What Ms. Golightly is expressing there is that the process of seeking the advice might have scared the horses. I think that's what she was referring to. However, your other point is that wouldn't a definitive legal advice have provided great comfort and a document upon which the department could rely in questioning those issues? That's correct too.
But in terms of scaring the horses, in that scenario, that if that did occur, that would surely be just a short-term thing. Getting a legal advice doesn't take long.
You're right, it is a short-term thing until the legal advice was received.
Might be a matter of weeks.
Correct.
It could be obtained urgently,
Correct.
within a matter of days.
Correct.
In terms of the horses in this statement, who do you understand that to refer to?
I'm not sure who Ms. Golightly was referring to.
Okay. You just go to the first page. The email at the bottom of the page from yourself
Yes?
to Ms. Golightly, dated the 21st of January 2017. You say, Melissa, not sure what action they could take. I'll get Annette to give us some ideas. We can consider external advice if we need it. Do you think there are any parts of this where we have been relying on internal advice that may need the reassurance of an AGS view? See that?
Yes?
And I suggest that you yourself recognise the value of getting an external legal advice,
Yes.
in particular, an AGS legal advice.
Yes. Yes.
Provide reassurance to the extent, I'll withdraw that, to provide reassurance on the question of the lawfulness of the scheme.
Yes.
And you draw a distinction between getting that reassurance from AGS and any internal advice that might have been the basis for the scheme to that point in time.
Yes.
And is that because you recognised that you would get a greater degree of assurance of the legal position by getting an AGS advice compared to relying on just internal advice?
Yes.
And is that a recognition that AGS has available to it far superior legal expertise compared to the legal expertise that the department had available to it?
In part, yes.
What do you mean by in part?
One of the reasons why you would seek AGS legal advice is, in fact, to answer the legal questions that you mentioned. But the other reason that one might seek legal advice is that in public explanation of a scheme, such as its Senate estimates, advice from the Australian Government solicitor was extraordinarily valuable in defending something more than private sector advice, for example.
And in contrast to just an internal advice.
Indeed. internal advice would not be terribly useful in that context.
Because, of course, the internal legal advice will be given by lawyers who will likely have, and I mean no disrespect, a lower level of legal acumen. Correct?
I'm not sure that I would agree with the remark, a lower level of legal acumen. Certainly they would have a less broad level of experience and access to, AGS would have access to a greater range of experience and documentation and precedents and so forth.
Lawyers with experience in public and administrative law,
Yes,
appearing in court proceedings involving disputes about public and administrative law,
yes,
in court proceedings involving the interpretation of statutes,
yes,
in the High Court,
yes,
for example.
yes.
You would not have that level of and breadth of expertise internally in the department at that time, correct?
No.
Did you also perceive any problem with the perception of departmental lawyers as completely independent?
That would certainly be an issue, and I mentioned that in respect of explaining the scheme to a Senate inquiry or a Senate estimates inquiry. Internal lawyers were less persuasive to those sorts of committees than any sort of external advice.
Well, they were departmental employees.
They were.
Right. Did you yourself think that the pressures on them as departmental employees, that there was any perhaps unspoken pressure to produce particular outcomes?
Not in this case. I believe that the relevant parts of legal division, which was the program advice area, provided pretty independent advice, and on a couple of occasions, although I cannot be specific about them, they told various parts of the department that they were unable to proceed as they wished because it was contrary to the law.
All right, thank you.
But this was a program that, as you've acknowledged, meant billions of dollars to the government budget, correct?
Indeed.
Which had been announced in the 2015-16 budget, correct?
Correct.
And this was a program that had gone live in September 2016
Yes.
and attracted substantial adverse media attention.
Yes.
And it would be profoundly embarrassing to the department if it turned out within a few months of it going live, and in the context of the announcements about how much budget savings it would produce, that in fact it was unlawful all along.
Yes.
And the department had a substantial interest in not acknowledging that the program was unlawful.
I actually don't agree with that. My answer would be, from the job that I was sitting in, which was to support the department, while you're right, it would have been very, very embarrassing at that point to have discovered the scheme was unlawful. But to be honest, would be far more embarrassing to discover the scheme was unlawful at a later date.
Yes. But given the prospect of how embarrassing it would have been to discover it was unlawful at this point in time, the time of these emails, do you recognise that departmental lawyers might have felt under particular pressure to give advice that might be thought to be favourable to the interests of the department?
I wouldn't accept that the lawyers would have done that. I mean, my experience of working with the legal division was that they were forthright, honest, and for the most part pretty capable.
Can you recall an occasion where they gave advice that resulted in an acknowledgement of the unlawfulness of a program being administered by the department involving this amount of money that was projected to save the budget?
No.
Can we call out the next email on the chain towards the middle of the page? There's a short email from Miss Golightly. Thanks, Jonathan. Not sure about your last question. Was that one for Annette, see that?
Yes.
Then we go the next email up. From Ms Mussolino to Ms Golightly CCing yourself, see that?
It's addressed to me as well.
Sorry, I'm just reading out the fact that it's
Okay,
CC'd.
sure.
And it says, Melissa and Jonathan, there is no obvious legal cause of action other than individuals seeking review of their individual debt decision. I don't think there is a legal advice, either internal or external, that considers the end-to-end process. That is something we could consider getting. See that?
Yes.
And then if we go the next email up, pull that out. Email from Ms Golightly to Ms Mussolino, dated the 21st of January 2017, CCing yourself, you see that?
Yes.
There's thanks, Annette. Could the three of us discuss on Monday the pros and cons of getting any further advice? See that?
Yes.
And if we call out the final email in the chain at the top of the page, see there's an email from Ms Mussolino to Sue Goff, dated the 23rd of January 2017, stating meeting is to discuss below. See that?
Yes.
Do you know who Ms Goff is?
I believe Ms Gov was Ms Mussolino's assistant.
Okay. All right. Do you recall whether this meeting actually occurred?
There is another stream of documents regarding which, perhaps I just do explaining. There comes a Ms Golightly's email of the Saturday, and stream splits into two streams of emails, which are both recorded in my statement. This is the first one, which finishes with the remark from Ms Mussolino to Ms Goff, asking her to organise a meeting about these matters. There is another email which came to me from Ms Mussolino, which actually recommends an end-to-end legal review, and following that there is a meeting organised between myself, Ms Golightly and Ms Mussolino. So yes, I think that meeting did occur.
It did occur.
Yes.
Do you recall what was said at that meeting?
No.
Nothing of that meeting you recall.
No.
In the context of the media attention that was attracted to the program at the time and the significance of the question of the lawfulness of the scheme, your evidence is you don't recall what was discussed at that meeting.
That's correct.
Nothing of that meeting.
Nothing at all.
We just call out again the second last email. Sorry, the top of the first page. Ms Golightly to Ms Mussolino, the 21st of January. You at least have a recollection that the topic of discussion at the meeting was getting the pros and cons of getting any further advice.
The topic of the meeting was obtaining further legal advice, yes.
External legal advice?
Yes, I think that would be fair to say is what we were talking about by this stage, yes.
Okay. And do you recall anything said about the pros and cons of getting legal advice at that meeting?
No.
And by pros and cons, do you understand that to be a reference to the advantages and disadvantages of getting external legal advice?
Yes.
What could possibly be a disadvantage of getting external legal advice?
Ms Golightly had already expressed in her very first email that she was concerned about, to quote, scaring the horses, unquote.
That's the only disadvantage you can think of for getting external legal advice?
Yes.
That might, quote, scare the horses over a couple of days if the advice was sought urgently. Is that right?
I don't know how long it would take to obtain the advice. The program was really very complicated. In Ms Mussolino's email to me, in which she sets out a number of points about getting the end-to-end legal review, which is the language she uses in her email to me rather than advice, There's a number of points. I would think that to get a considered piece of advice would have taken much more than 2 days.
How long?
I really can't speculate, but when you ask for an urgent piece of advice over 2 days, you've really got to expect to have a pretty simple, straightforward question. Ms. Mussolino's email to me set out, I think, 6 points, and in those points it was pretty obvious that the questions were going to be quite complicated and require some degree of thought.
So you expected that getting external legal advice was going to take how long?
I don't know. I can't speculate, but it would have been more than a couple of days if we had wanted to have a proper considered piece of legal advice.
A couple of weeks?
Possibly, yes.
Maybe up to a month?
Possibly. Month would have been getting long, I think.
Okay, so possibly 2 weeks, maybe a little bit more.
Indeed.
And could there be any serious risk to the program of having to wait a couple of weeks to get a definitive legal advice about the lawfulness of the program?
I can't think of any.
No. You know whether or not an external legal advice was sought?
No,
Can you explain why it wasn't?
I
Sorry,
don't
that-
know. My question was, I don't know.
No, you don't know whether the advice was sought, or
That-
no, it wasn't?
Commissioner, that's correct. I don't recall the outcome of the meeting which followed that's described in this document. And the outcome of that meeting could have been to commission further legal advice or seek some other process before legal advice was sought, but I don't recall any of that.
You recall at any stage any discussion with either Ms. Golightly or Ms. Mussolino where a disadvantage of obtaining external legal advice was identified as that the external advice might be unhelpful to the department?
No. Don't recall any such discussion.
That is, might confirm that the program was unlawful.
I don't recall any such discussion.
Okay. And you have no recollection at all of whether or not any external legal advice was sought after that meeting?
No.
All right, that can be taken down. Now, you recall that in January 2017, the Ombudsman announced that it was going to be investigating the Robodebt scheme,
Yes.
and you were involved in the department's response to that investigation.
Yes.
Can the witness please be shown document CTH.3001.0033.6782_R, Exhibit 1312. If we can go to the bottom of the third page of the document. I call out the email dated the 16th of January 2017. It says, "Colleagues, I've just received advice that the Acting Commonwealth Ombudsman, Mr. Richard Glenn, is attending the briefing on Thursday too, for your information." Do you see that?
Yes.
And you see further up the page an email that starts at the bottom of the previous page. Ms. Golightly to Mr. Robinson CCing you.
Yes.
See that? Subject is Commonwealth Ombudsman own motion investigation. See that?
Yes.
And note is that Ms. Golightly says that this means that I should probably go to. See that?
Yes.
And does this confirm to you that by about the 16th of January 2017, the Ombudsman's investigation was on foot?
Yes.
Okay. And then we go to the previous email on the chain, the next one on page 2. So towards the bottom of the page. See, that's an email from yourself,
Yes.
Golightly,
Yes.
and that's the 17th of January 2017.
Yes.
It says, I've just got it, access back. I'll
Yes.
go to.
Yes.
What could the words, I've just got it, access back mean?
I think that meant IT, information technology access.
Oh.
As I read that, I believe there must have been some problem with my password or something and I didn't have access.
And you say, I'll go to.
Yes.
And that's to the meeting with the then acting Commonwealth Ombudsman, Mr. Glenn, as referred
That's
to.
correct.
In emails. Thank you. Then if we go to the next email up, starts towards the top of the page from Mr. Robinson. And that's dated the 17th of January, addressed to Ms. Golightly. Aaron Harfield, Scott Britton, Annette Mussolino, Mark Withnell. See that?
Yes. And it was addressed to me as well.
Oh, yes. I got lost in the redactions, thank you. It says, Melissa and Jonathan, the Commonwealth Ombudsman's Office advised that the Ombudsman does not usually conduct formal entry meetings when commencing own motion investigations. However, given the high profile and the speed at which the OO, being the Ombudsman, is wishing to complete this investigation and publish a report, the OO agreed to hold an entry meeting on this occasion. Do you see that?
Yes.
As such, there is no usual agenda for such meetings. Would we be right in understanding that it would be unusual for the Commonwealth Ombudsman to hold an entry meeting for one of its own motion investigations?
Yes.
What is an entry meeting?
An entry meeting is more common when we have an investigation by the Australian National Audit Office. The process there always involves an entry meeting with people at fairly senior levels, so I would have attended many of those. The purpose of those meetings is not that different to the purpose of this meeting. My recollection is that it was the department's proposition to the Ombudsman's Office that given the speed and sensitivity of the issue, it would be useful, their proposed speed of reporting and the sensitivity of the issue, bearing in mind the substantial criticism that you mentioned earlier, that an entry meeting would be useful.
What happens at an entry meeting?
I think it's in one of my documents in evidence that the purpose of this entry meeting was to introduce senior staff to each other. So it's not just the senior people such as myself and the Commonwealth Ombudsman and Acting Ombudsman and Ms. Golightly, but also the other senior staff who are going to be doing most of the work. I mean, we're the senior executives, but most of the work would have been done at a lower level, both within the Ombudsman's Office and within the department. So we introduce people to each other. We start to set expectations in which the Ombudsman, for example, would tell us what sort of time frame they're going to have, what the process will be for seeking and exchanging of documents and meetings and so forth. It would also have provided me with an opportunity to portray myself to the Acting Ombudsman as his lead contact within the department. And if you look at other documents within my document pack, you'll see that we did have correspondence and further meetings from time to time.
So what was the relevance of the media attention to the need to have an entry meeting that you just referred to?
Because it made the program more sensitive.
Sensitive in what sense?
Sensitive in terms of public perception of the program, sensitive in terms of the level of interest in the Ombudsman report.
So why would that justify an entry meeting? Normally.
Well, the purpose of the entry meeting wasn't just because of the sensitivity, it was also because of the speed of proposed reporting by the Ombudsman, and it enabled both sides to have a more efficient start to the process. The sensitivity was because normally an own motion investigation would not normally involve the level of interest by the Ombudsman that this one did. They commenced, the start of this was the letter from the Ombudsman to Ms Campbell of the 10th of January. So it started pretty early on in the process. There had been public calls for a ANAO investigation, but the Ombudsman had decided to conduct his own motion investigation.
What I'm seeking to understand is your statement made a little earlier that one of the reasons why it was necessary to have an entry meeting was because of the sensitivity. So I'm just trying to understand the connection between sensitivity and the need to have an entry meeting.
The entry meeting, as I said, was designed to improve the efficiency of the process. The sensitivity was because of the level of media interest and the amount of attention that was being focused on this matter, both within the department and within the Ombudsman's office. The entry meeting was aimed at dealing with those, was aimed at elevating the importance of the Ombudsman's investigation, both within the department and the Ombudsman's office, I believe.
Go to the next email up, which starts at the bottom of the previous page and commences at the top of this page. It's an email from yourself to Mr Robinson, Ms Golightly and others. Okay with me, you say? See that?
Yes.
17th of January.
Yes.
Go the next email up. 18th of January from Ms Mussolino. Just call it out. There's two emails actually.
Right, okay, so the one of the 18th of January at 9:22 a.m.
Yes.
Okay.
Refers to some attached talking points.
Yes.
And then the one up that responds from Ms Golightly says, I think the overall is fine, just have some comments. And the words are, I think the bit about enhancements should come after the statements about the system working as it should. The PM and the Minister talk about it in this order. The PM has also backed it in today, so we should mention that he did this after he sent this version to me. And we can go to the top of the page. Ms Mussolino, email from her to Ms Golightly and and yourself, dated the 19th of January 2017, attaching talking points. See that?
Yes.
And the email says the attached talking points for today's 2 p.m. meeting. Do you see that?
Yes.
All right. Now, that document can be taken down. And could the witness please be shown document CTH.3001.0033.6785, Exhibit 1312. Now, this is the attachment to the email that you were just shown.
Yes.
And you can see it purports to be the talking points that are referred to in that previous email.
Yes.
You can see second bullet point, thanks, identifies as a talking point a thank you for the letter to the Secretary and to the Minister, advising of the investigation by the Ombudsman. See that?
Yes.
The next bullet point expresses a hope that the report will correct some of the inaccurate reporting in the media recently.
Yes.
See that? In the third bullet point, The point is made that the department is investing considerable resources in addressing concerns raised by customers and their representatives, supporting customers and correcting the public record at every opportunity.
Yes.
See that? And then the next bullet point, the statement is made, our Minister, Minister Porter, over the Christmas period and the Prime Minister just yesterday have all been very firm in backing the program.
Yes.
See that? And does that accord with the comments made in the email from Ms Golightly to Ms Mussolino that was forwarded to you that I showed you just moments ago about the reference to the PM and the Minister?
I believe so, yes.
Okay. Now, do you recall matters to the effect of what's in this talking points document being discussed at the meeting with the Ombudsman?
I don't have any recollection of the meeting with the Ombudsman.
Okay. You have a recollection of this talking points document?
Yes, because I reviewed them in my document pack, and I do remember that it would be common for my staff to prepare some talking points for me for a meeting of this sort.
Okay. What would be the significance of having talking points referring to the Minister and the Prime Minister being all very firm in backing the program?
That's a matter of informing the Ombudsman of the context with which we were working.
Why is that significant?
Because the Ombudsman would want to understand the context with which we were working.
And how is that relevant to the Ombudsman's inquiry, that the Minister and the Prime Minister were very firm in backing the program?
I'm not familiar with the Ombudsman's thoughts in this area. We thought they were useful remarks to make. Whether they were particularly relevant for the Ombudsman or his inquiry is a matter for the Ombudsman.
Why did you think it was relevant?
Because we thought we would explain to him the context in with which we were working in respect of this program.
Were these words intended to influence the Ombudsman in its investigation?
No. The Ombudsman's a statutory office holder. He makes his own decisions.
So if it wasn't intended to influence the Ombudsman, why mention it?
To explain to the Ombudsman the context within which the department was working.
The department was very concerned, wasn't it, about the prospect of adverse findings being made by the Ombudsman in its investigation report.
That was one option that could have occurred as a result of the Ombudsman report, yes.
And one such adverse finding might have been to criticise the underlying policy of the program, correct?
Could have been, yes.
And I suggest to you that the point of this proposed talking point was to convey how much support the policy had from the Minister and the Prime Minister.
That was part of the context within which the department was working.
And it was identified as a talking point to discourage the Ombudsman from criticising the underlying policy of the program.
I don't agree with that.
What was it for? Did you want to communicate that you were doing the behest of political heavyweights? What was it?
It was about the context within which the department was working. This was a really major program, as has been noted. Okay, it was clearly a program that had strong political support, and you see that from this statement. And that was certainly the context within which the department was working.
Well, it does tend to convey that the department was under strong political imperatives with the program. Would that be fair?
Yes.
All right.
Can we just call out the two previous bullet points again together? And as you recall, the first of those two expresses a hope that the report would correct some of the inaccurate reporting in the media.
Yes.
And you agree that it was hoped that there would be findings made by the Ombudsman in its report effectively agreeing with the department's position on what the department considered to be inaccurate reporting by the media.
Yes.
And the point of including this talking point was in effect to express that hope to the Ombudsman at an early stage of its investigation,
Yes.
so that it was alive to that desire that the department had from very early on in the investigation.
Yes.
And as to the second of those two bullet points, which refers to the department investing considerable resources in addressing concerns raised by customers and their representatives, supporting customers and correcting the public record at every opportunity. See that?
Yes.
That was a reference to the changes that were being actively considered by the department and the minister at the time this inquiry was happening.
Yes.
And the point of communicating that to the Ombudsman was to indicate that to the extent the Ombudsman might have concerns with the program, they were already being addressed by the department.
Certainly, many of the concerns which had been identified prior to the Ombudsman's, prior to this meeting, were already being addressed by the 17th of January, yes.
And would it be right that the point of communicating that, even at this early stage in the investigation, was to reduce the risk of adverse findings in the Ombudsman's report about the matters that were being addressed by the department at that time?
No, I don't accept that. It was about explaining to the Ombudsman that we were actively pursuing improvements to the program, addressing the concerns raised by customers.
By engaging in those changes at that stage, was the department trying to reduce the criticisms that might be made in the Ombudsman's report?
The changes that were being made to the program were being made to the program because they needed to be made. Part of that would have been to address concerns of the Ombudsman. That's true.
That can be taken down. Can the witness please be shown document CTH? Actually, Commissioner, I note the time, and bearing in mind.
Have you a rough idea how much longer you'll be with Mr. Hutson? I'm just thinking about when we resume. I'm not going to indicate the time we're going to adjourn to just yet because I don't know how long we'll be in this next session. But I just wondered if you had any idea how long.
I think I'll take the balance of the day with him.
Okay, so 2:30 we need to be back by, you think?
Yes, I think so.
All right, okay. So, Mr. Hutson, we'll let you go till 2:30. We've all got to do something else now. So we'll see you back then, please. Thank you.
Thank you, Commissioner.
And I'll just adjourn while things get set up
Thank you,
for the
Commissioner.
next session. We'll adjourn briefly.
All rise. The Commission stands adjourned for a short break. Royal Commission is now in session. Please be seated.
All right, can I have appearances, please, Mr. Scott?
The Commission pleases Scott, initials AD is my name, of King's Counsel, up here with Miss Berry to assist the Commission.
Thank you, Mr. Glover.
Yes, may it please Commissioner, I appear for the Commonwealth.
And Dr. Renwick.
Yes, my name is Renwick, initials JG. I appear for Mr Morrison, instructed by Clayton Utes.
Thank you. Mr. Renwick, I think I will get right to the point on the issue of whether this ought to be a public hearing at all.
Yes.
This is what puzzles me about it. Your approach seems to be to say that Mr. Morrison has responded to a notice from the Commission, he's answered a number of questions and referred to a number of documents, and that it's necessary that all of his answers and all of the documents be produced. Now, I have great difficulty in understanding how I can resolve issues about specific documents without being referred to them by you with an explanation of why they matter. And to give you examples, Mr. Morrison refers to Economic Review Council meetings with dates and a modest level of detail, to Cabinet
Yes.
meetings, to Cabinet minutes and the minutes of the ERC meetings.
Yes.
And I have trouble seeing how any of that advances me or advances Mr. Morrison for that matter, when one's concerned with government decisions which are identifiable by other means altogether. Or to take another example, the correspondence concerning the settlement of the class action, when it's known how the class action was settled and what the basis of settlement was, why anyone needs to go to the actual letters that were sent to Mr. Morrison. Now, it may be that you have excellent answers to all those things, and I'm very keen to hear them, but I don't understand how I can get those answers without us discussing the documents in question.
Can I answer that directly?
Great.
What is sufficient for my purposes, Commissioner, is to make good the proposition at paragraph 17 of our written submissions, which is at page 37 of the bundle.
All right, just bear with me. But that seems to me to conflate two separate issues, whether there's been an adequate answer to the notice, which I don't think anybody's arguing against, and what needs to be produced in public for the purposes of this inquiry.
All right. So that's my fundamental proposition. To answer your Commissioner's next question, how can we do this in public today? My answer to that is, it is sufficient for my argument to take you to 3 passages in the Morrison statement, the unredacted statement. I am very confident I can take you to it and say, please have a look at paragraph 3 and so on. I won't read it out. I won't divulge it. And if at the end of my submissions, Commissioner, you say, well, I'm not satisfied, I need more detail document by document, it's at that point we might need to go into private session. But I'm very confident I can, in about half an hour, take you through my propositions, take you through the 3 particular examples to make good paragraph 17. But can I directly finally answer, Commissioner, your last point? And it's a combination of things. The first is, what has happened is we've been given a compulsory notice, which we have conscientiously answered. No one on the Commonwealth side is suggesting that notice should be set aside. You have the answer, you have the statement, you have the documents. Now, there is some suggestion in the interim ruling that that would be kept by the Commission, even if the PIA claims are upheld, we think there are considerable difficulties with that because we don't think Mr. Morrison can then give true, complete and correct evidence consistently with his statement. So that's proposition one.
Well, just,
Um,
I'll make some
yes.
notes as you go, so give me a little
Yes,
time.
please. Most helpful. I'm sorry, Commissioner, did you want me to go on or did you want us to
No, just
make an...
give me a minute.
Yes, certainly, Commissioner.
You're going to come back to these things, I take it, or not?
Yes, so my submission at the minute, Commissioner, is that we spend, with your permission, I take you through the tender bundle, the unclassified tender bundle put together by the AGS, which is available to you now. And at a suitable point, I take you to 3 parts of the unredacted Morrison statement, which I am very confident, as is Mr. Glover, who I've spoken to, I can do without trespassing on any of the current PII claims. That's my first application.
Yes, I understand that, but you'd given me this proposition that he wouldn't be able to give true answers consistent with his statement. You can give true answers without going into the detail in the statement, surely?
I think I need to develop that by reference to the tender bundle. It won't take me very long, but thank you for indicating that's a matter on which you want assistance, Commissioner. I think I'd need to take you to a particular example to make good that proposition. Would you like me to begin my submissions, Commissioner?
Yep, go right ahead.
Yes. So could I request that Council assisting tender the tender bundle? I gather that's the procedure, and then I'll take you to particular parts of it.
Commissioner, I have a copy of the tender bundle here, but it was my working copy. It's just been handed to me.
So by the tender bundle, are we referring to the folder that I have, which has...
Yes, it has those documents set out on the screen now, Commissioner.
Okay. I just want to flag something, so again, give me a moment. So this has got to be...
I'm instructed we have this electronically, so I'm in a position to tender it.
Okay, because I don't really want to hand over my copy as the exhibit if possible, so we will make it an exhibit, but it had better be the subject of a non-publication order, Mr. Glover, or what do you say?
It's unnecessary for that to happen, Commissioner. What the Commonwealth can do is prepare another hard copy so the Commission can have that for its records.
All right.
For the avoidance of doubt, now that I think about it, it might actually be preferable to mark that exhibit as a confidential one and place a non-publication order over it, just for the avoidance of doubt.
All right, well, it's subject to a non-publication order.
Well, all right.
Further order.
Okay. It's just that that's news to me. I had understood it was entirely unclassified and I propose to make reference to it now. Do I have permission to do that?
Yes, you do. I think you'll need to.
Thank you.
And I'm not sure how much of it would need to be. I think Ms McGregor's statement, there was some concern about parts of it. So it may be a bit absolute to make the whole thing subject to a non-publication order, but till I have the opportunity to think through something more specific, we'll proceed on that basis, but you have leave to refer to whatever you need to.
Yes, Commissioner. So if I can begin then with Mr. Morrison's redacted statement, which is at page 494.
Okay, and I think, in fact, that portion of the tender bundle need not be subject to any non-publication order.
Yes, just looking at the what's on the screen now, presumably, Commissioner, every item except for perhaps Ms McGregor's statement, my submissions, for example, and the other submissions, there's no reason, surely, for those to be the subject of any non-publication order.
Okay, Mr. Glover, do you have any different position?
No, I don't. You're right.
All right, just Ms McGregor's statement then will be the subject of the non-publication order. Thanks, let's get moving on this.
Yes, I'll get on with it. Right, so page 495
Yes,
is the second page of Mr. Morrison's statement.
yes.
So the starting, if that could go up on the screen. the starting point is, Commissioner, of course, as you know, the 46 pages and attachments which Mr Morrison has put together are in response to the compulsory notice from the Commission. He was required to produce it. He has produced it. What is here is his true, complete and correct answer to your questions. If the notice was to be varied, that might be a different matter, but we don't understand the notice is presently to be varied. And in any event, as an historic document, there it is. He's prepared it. So that's proposition one.
All right.
Proposition.
Can I stop you there? I don't know that proposition one takes you very much further in terms of public interest immunity. He has answered the questions, but people answer questions just in the abstract in lots of ways which may not be of burning relevance to anything. So it's not really essential that the answers be on the record. So why does the fact that this is his answer to a notice mean that somehow the whole of it must be before the public? Or that he can't give correct, sorry, I interrupted you, but that he can't give correct evidence, correct and true evidence without referring to every bit of it.
Right. Well, let me give a practical example then. If one turns over to page 497, as you recall, Mr Morrison has held 3 key ministerial roles. Can we put this up on the screen, Commissioner? Is that possible or not?
I imagine so. I'll see what we can do about it. The trouble is I'm not sure that it's actually entered the system. What's the...
No, it has entered the system. I think the instruction went to...
Oh, probably to... You see, Dr Renwick, the Commission has been kept on a very tight leash by the Commonwealth on this stuff, and the access to the material has been very limited indeed. So as a result, I think that this material has not been converted in a way that will enable us to put it up on the screen now.
I see. Thank you, Commissioner. Not to worry. So, but you have in the tender bundle, page 497. So go back a step. Mr Morrison held 3 key positions, as you know, Minister for Social Security, Treasurer and Prime Minister. In the statement at 497 through to 499, you'll see there are significant redactions in answer to question 2. Question 2, and of course everything in the notice is public, is during what advice or information, including legal advice, did you receive about, e.g. the Robodebt scheme? So there are significant portions which are redacted there. But then when you come to the chronology number 1, which begins at page 500 and goes to page 504, there are significant discrepancies. And while you have that open, Commissioner, I understand you would have the unredacted or full Morrison statement in front of you in paper form. Would I be right about that?
You are right.
So can I take you then, and I am conscious that I need to be extremely careful about this. So if you go to page 8 of the statement, which is begins at page 501 of the public tender bundle, you will see all of page 502 and 503 is blacked out. And you will see that there are considerable details in the material set out there and in the following page. As we understand your preliminary ruling...
sorry, can I stop you a minute, Dr Renwick? There's a problem apparently.
Apologies, it's not with anything my learned friend Dr Renwick has said. When he goes to page 503, according to our reading of your preliminary ruling, Commissioner, item 11, which...
that's my mistake. You were quite right, Dr Renwick. It should have been item 12.
Thank you. But in fact, what I wanted to take you to, and thank you to Mr Glover, is the last 3 lines in item 10, which is immediately above item 11. As I understand your preliminary ruling, those are the only portions which are to be where the PII claim is to fail. And it follows from that, as we would understand it, that you will not have regard to and you could not rely on any of the other material in item 10 or the material underpinning it. Now,
All
this
right.
is where I come to answer your question, Commissioner, as to why do you need the underpinning material, which I understand is an important question. The broad answer is this. At this stage of the inquiry, when the lines of inquiry are open, and of course you won't have formed a final view about anything, I dare say, if you are not to receive in one form or another the material underpinning Mr. Morrison's statements and assertions, you will be stuck with them. I may be thinking to make a point against myself here, but if he says I did X because of document Y, and you do not have document Y, and that's the consequence of upholding the PII claim, then you will never be able to come to a finding based on all of the evidence. And in my respectful submission, you will have failed to have done, you have failed to inquire in a manner where a document is readily available to you. That's the short point.
Okay.
There
but
may come
sorry,
a time, of course, where that changes.
but I don't see that that argument can work across the board. I completely see your point about item 10. I thought it was the sort of thing that you might want to make submissions about, and that's why I gave leave for that purpose. But it is not in the same category as, say, a reference to a cabinet minute, which will just tell us, we can imagine, that the government of the day took a decision, which we can discern from other factors, and it's not likely that something like the cabinet minute is going to reveal any particular individual role of your client. So that's why it seems to me that these things have to be gone through on a line-by-line basis, because although there may be great merit to this argument about this item, it doesn't work for everything.
Well,
But
can I press on?
press on.
I note what Your Honour says, and of course we are at your disposal in a private session to go through everything in private, in full detail, as you wish, Commissioner. But can I just make the point by reference to two other documents, and I can do so quite quickly. If you turn to page 17 of this document, which is page 510 of the tender bundle, as I understand it, the entirety of item 4 is the subject of PII, as are the documents on the right-hand side. Could I invite you to read, please, the third last paragraph from the bottom of item 4, and you will see why that is a fundamental matter which Mr. Morrison wishes to rely on in view of the terms of reference.
Yes, and I do understand that, and I think it emerges pretty solidly from documents that I have ruled in favour of.
Well,
But again, it is a fairly specific thing, and it is the sort of thing I think we could talk about in more detail to establish. You see, it's not just whether the documents come in, but it's which bits of the documents, Dr. Renwick, because if you admitted all of these documents, you would find yourself looking at information about family tax benefit, which will not advance anybody at all. So it needs a bit closer consideration, it seems to me.
and I'm with you on that, Commissioner. The concerns I've got at the minute, in particular, are where what is in the body of Mr. Morrison's statement is being the subject of the PII. That's the core of my concern, and the one I have just referred to. Take that as an example. Perhaps that is said elsewhere. Perhaps you can glean it from elsewhere. But why, I ask, would the Commission not want the best and most direct evidence of what may be a contested fact? And that is something which should be made public. It's self-evidently important for Mr. Morrison's defence of criticisms which have been made against him.
Yes, I'll have to check, but I suspect those documents are in another place, but all right, that's one of your issues.
And again,
Mhm.
if that is so, if it is in another place, that's the end of the public interest immunity claim by the Commonwealth in relation to that item. There is no longer a claim.
Well, you see, you want to talk about the content of a letter. It gets a bit more complicated, which annexes the documents, and it's only in relation to the documents themselves that it said there's an interest. So why would the letter go in? You see, one has to be careful about these things. You don't produce any more than you need. So
So,
those issues arise.
well, can I firstly say, Commissioner, take the example of budget papers, and I'm not going to reveal anything I shouldn't here.
Mm.
We entirely accept the Commonwealth can go through the detailed budget papers and say, of course, items 1 to 100, hypothetically, are wholly irrelevant to the Robodebt matter. And providing we can check that ourselves, we would be entirely content with that. That's not what the Commonwealth's done, of course. The Commonwealth have taken the perhaps surprising step of saying, although we are not going to tell you, Commissioner, which bits are more sensitive than others, we want to protect cabinet confidentiality globally. And that is where my client has run into so many difficulties. I am content with what you have just proposed. That is to say, if Mr. Morrison can put in what is contained in the third column there, which is the explanation by him,
Mhm.
and the references remain, and to the extent the references directly support what he says, and that's something we stand ready to work with the Commonwealth on, then I would be content with that. But I would then say for those matters, that means the PII claim on those fails for reasons I come to. It's then a matter for you, Commissioner, of course, as to whether there's to be a non-publication order over matters which are not the subject of a successful PII claim. So the only other reference I wanted to take you to today, Commissioner, is on page 35, which is at page 528 and item 15. Actually, it's the next page. It's page 529. As we understand it, if you look at just above item 16, if you go up 3 paragraphs and you see there's italicized writing for the first time at about point 3 in the page, can I invite you to drop down 2, 4, 6 lines and just read from there until the end, and you will see that is at the heart of Mr. Morrison's defence.
Yes. What you've done is identify for me 3 items where I can quite see your argument, quite see your point.
Thank you.
But somehow you want me to extrapolate from those for everything else, and I just don't see that it works. I'm very happy to go away and consider those items and where we should be left on those. But that doesn't lead me to the point of saying, well, every charter letter must go in, because I'm not sure why. We accept that I've already said that Mr. Morrison could simply say Robodebt was never identified as a priority to me. And I'm sorry if you were hoping to appeal that part of it, Mr. Glover, but I've just disclosed it. You see, the argument on these 3 items looks pretty good, but I don't see that it follows across the board.
Right. So may I just then spend another 10 or 15 minutes just expanding on my argument, and then I might ask through you, Mr. Glover, Commissioner, as I understand it, they're not appealing your decision at all, firstly.
Is that right, Mr. Glover?
And
Yes, Commissioner, I can indicate, and I had hoped this had been brought to your attention, on the basis
I
of
like things on the record.
on the basis of the provisional ruling, the Commonwealth won't appeal or seek judicial review, to put it more properly, of your decision on the basis that it's in accordance with legal practice and principle.
Okay. All right, so we've got that far. Sorry,
So-
Dr. Rennick.
Commissioner, I'd like to get to the position where in the next 15 or 20 minutes, I will have done my best to persuade you that where Mr. Morrison refers to something in his statement, in principle, and in answer to a notice, in principle, that is something which he should be allowed to state publicly, notwithstanding the PII claim. And if you are in principle in favour of my client on that, if you could indicate that at some stage, then Mr. Glover and I can sit down and work through the documents. It's a lot of work, of course, but we can work through the documents and get them in a state where I doubt there will be an argument next Wednesday week when Mr. Morrison gets here. I'm just trying to come up with a practical solution for you.
But Dr. Rennick, I would have thought a practical solution was for Mr. Morrison to refer in general terms to the government decisions, which I think we can all proceed on the basis were made in accordance with usual ERC and cabinet processes. It's not clear to me why he would need to talk about particular ERC meetings, although there may be some particular documents that came through to them that you have referred to, which need to be before me. He could refer in general terms to the steps that were taken in relation to the class action without going through the correspondence that was sent to him. He could refer in general terms to his writing instructions through charter letters. I just don't understand why those documents, or why his level of detail in relation to the existence of those documents gets anybody any further.
Because, Commissioner, his reputation is on the line and he is entitled to answer the notice in a complete fashion, which seems to him to be complete and truthful. That's what he's done.
But
Now, of course, we may
how is
accept
his
that.
reputation on the line when he expresses something as a general decision of government as opposed to, well, it went through ERC and that happened on this date with, I don't think there's an enormous level of detail, but there is some, or it went through cabinet and this happened on this date. Why does that make very much difference?
It makes an enormous difference because it's a collective decision of government as a whole following proper processes rather than a decision of an individual minister. And it's no doubt a vital finding of fact which you will need to make to answer your terms of reference.
But that's precisely my point. We can see that these are government decisions. There's no reason to suppose they are anything else. Why do we need to go into the intricacies of cabinet and ERC when there's a public interest in not doing so, when there is just no evidence or basis to suggest that he took any particular role in relation to cabinet decisions? And I'm just setting to one side his position as Minister for Social Security because there are particular documents produced there that he is in a completely different frame of reference for. But in his capacities as Treasurer and Prime Minister, I don't think there's any basis for a suggestion that these were not collective decisions of Cabinet. And so I'm struggling to see why his reputation's at risk on those.
Well, perhaps the best thing I can do next, Commissioner, is just come and take you as quickly as I can through our submissions. I won't take long, but I can see I need to spend just a little time with respect to take you through it. And I suppose the other answer to what, Commissioner, you've just put to me is that if he can't refer to ERC or cabinet matters generally, how can he say that on this date the ERC did this, on that date the cabinet did that?
Why does he need to? I'm sorry, Dr. Rennick, I cut you off. But why does he need to? Why does he need to say on this date the ERC did this or on this date the cabinet did that?
Well, because, and let me take you directly to it, because if one looks at our submissions at, for example, paragraph 24, and I don't say this in a critical way, of course, Commissioner, but what we have to go on is what the Commission has said publicly. And you've said here that what advice, consultation, reasoning or response to criticism was occurring behind the scenes at any stage. Well, that obviously includes what's going on in Cabinet or the ERC. That's why we've put a comprehensive response in. And of course, quite rightly, in the next paragraph, you've referred to people in senior positions who had or should have had oversight. That's why we've been comprehensive. And equally, at paragraph 23, counsel assisting raised it in the opening as a possibility that there was some reckless indifference to the lawfulness or otherwise of the use of the data, serious matters requiring a serious, comprehensive response. That's why we've gone into detail. And we hope that when you hear from Mr. Morrison, that's the other thing, of course, Commissioner, his evidence will be that much shorter because he's tried to be comprehensive. But let me just spend 10 or 15 minutes, if I may, just taking you through the high points of the submissions. At page 34 at the beginning, this aspect of the matter, we say, is exactly on all fours with the Pink Bats Royal Commission and Prime Minister Rudd. I've read what you said, that it's not exactly on all fours, but in this respect it is, with one exception. Mr. Morrison doesn't suggest, and I don't think anyone else suggests, that what was actually discussed in Cabinet or the ERC should be disclosed. He doesn't disclose it. No one suggests that should be done. After all, if you were going to do that, you'd be calling all the ministers in 3 administrations. But what Mr. Walker says there about the government can't require you to report faithfully and prevent you from pursuing the evidence about it or committing the unfairness of not permitting the Prime Minister of the former government to give his answer to the allegations is precisely the situation the Commonwealth is putting us in. And that's why we're here. In paragraph 5, there's a reference to, of course, the terms of reference repeatedly refer to the actions of the Australian government, and obviously the Cabinet and its committees are a formal aspect of that. To answer your Commissioner's question about why did we attach documents, it's because, see paragraph 12D, the notice required us under compulsion of law with criminal sanction to attach documents that record or evidence the event, action or decision.
I don't think I asked you why you attach documents to your response. What I'm asking you is why you then need them to be produced and made public for the purposes. And actually you did attach documents, as far as I know, you identified documents. But the question is why the public interest immunity privilege shouldn't prevail in respect of them unless they're particularly important to an answer.
Indeed. And that's a different question, but in answer to your, I think your earlier question, why did we do it? That's why we did it. Let me come to, and I've already accepted that there are large parts of these documents that with the Commonwealth's permission and help, we can rule out with counsel assisting as completely irrelevant. Paragraph
can I stop you there? Does that extend to things like Cabinet minutes and ERC minutes? Because it doesn't seem to me that they advance anything.
There we are at cross purposes, I think, or we have to disagree. There will be some instances, and I've taken you to 3 today.
I think they were submissions, weren't they? I don't think you actually took me to any minutes.
Oh, yes, I'm sorry. So submissions, so this is a case where one is not looking at the discussion within Cabinet. One is looking at what was put to Cabinet by ministers in the form of submissions, and one is looking at the formal record, which is often very anodyne of Cabinet decided to do X or Y. Those are the 2 sides. We are not looking into the black box of what was actually discussed in Cabinet. But if you wanted an example, item 13 in chronology 1 is an example of that. But let me press on.
Oh, no, just let me have a look at that.
Will you take you to that? Yes.
And bear with me while I sort through these various documents.
There's a Cabinet paper referred to.
Yeah, and what I want to understand from you is, do you press that the Cabinet minute itself ought to be produced, or are you just arguing for the statement contained in item 13?
Just excuse me. Yes. No, I think, Commissioner, if what is in this goes in and the Commission does not want to receive the minute underpinning it, well, we'd have to look at that. But step one is, does what is in the main, the third column go in? We'd have to look at the minute. But can I answer this? We would accept that anything in the minute which referred to things other than Robodebt, of course, doesn't need to be produced and would be the subject of a PII claim. We
Okay,
accept
well,
that.
presently I don't understand why the minute itself would be, but I don't even see at the moment why the item itself is necessary. Why isn't it? We know that a strengthening the integrity of welfare payments measure passed as a measure in the budget. So why do we need this?
Well,
And
I
this
suppose
may be
it
where
is
we
the
need to get to detail in private session, I'm not sure, but where does it get
Oh, no.
us?
Yeah. Well, there's two answers, I suppose. This is early days in your inquiry. It's not up to me to say whether avenues of inquiry should be shut off now.
Well,
But
they won't be
my
shut
answer-
off. If I came to the conclusion there actually was a public interest in having that information, as opposed to the general information that the government decided to do this thing, I dare say I could revise my ruling, but presently I am struggling to see why it advances the Commission's inquiries or Mr Morrison's position to know exactly what the Cabinet decided as opposed to the government adopted this measure.
Well, we do rely on it, and we rely on it in its context. I can't say any more in the public session. But of course, the consequence of a ruling like that would be that you could not have regard to the document over which there was a successful PII claim. Maybe it could be kept as an exhibit on the voir dire, as it were, but it could not be relied on by the Commission, and it certainly couldn't be relied on against Mr Morrison because he wouldn't be allowed to speak about it or respond to it. And that's the practical problem we have with this global claim by the Commonwealth. It is going to cause enormous practical difficulties, as it would have for Prime Minister Rudd. You remember what happened in that case was that he said, I can't swear to the truthfulness of this statement in part. And that's one of the difficulties we face at the minute. Now, it may be, Commissioner, the notice is to be revised. It may be counsel assisting tells us we don't need your evidence on X, Y, and Z. And if they tell us that, we'll deal with that as best we can. I'm not going to deal with that on the run. But that's the practical difficulty here of the Commonwealth coming in with this global claim. Let me just press on, if I may, with the submission so you understand the full extent. That is why I come to the proposition which I began with at paragraph 7. What we're talking about here is what Mr Morrison created, saw or used. So the starting point is, of course, he's not having anything disclosed to him. He's the creator or user of this, and he's entitled by law to have access to all of this. And if you go forward then to paragraph 20, we are very concerned about practically how this is to work. And I make the point there that if key evidence which he wishes to rely on, you may find at the end of the day, Commissioner, that you don't think it's persuasive or important. But as a witness facing a compulsory notice, he is entitled to put his best foot forward and answer your questions. And that's what he's conscientiously done. And if that's not to be done, we say he couldn't fairly be criticised in that respect in the final report. We make the point at the end of paragraph 21, what is it that he will be asked by counsel assisting on Wednesday week to adopt as true, correct and complete, when at the minute it won't be those things? And what is the Commonwealth going to do every time Mr Morrison says, well, actually, there is a reason I did that and I'd like to mention it? The Commonwealth's going to say, no, Cabinet can't mention it. It's going to cause enormous practical difficulties.
Well,
Let me press on.
it would be helpful if in private session you could identify those parts which do relate to a reason he did things, as opposed to
Yes,
the
I
general.
can certainly.
As
I can. Sorry, I'm interrupting you. I beg your
No, I
pardon.
think we're interrupting each other pretty effectively. But as opposed to the general statement that I need all of this.
All right.
Mm.
Let me press on. I won't be much longer. If you go to paragraph 37, we've set out there part of your interim ruling. And there in the second last line of the quote, you say certain things, this is the collective decision point and how much can be inferred and so on. We say you'd rely on the best evidence, firstly. And secondly, to repeat myself, it's an important part of Mr Morrison's answer to any criticisms that these were decisions taken by the government or through Cabinet or one of its committees.
But Dr.
Pressing
Rennick,
on.
if we know that these were government decisions, why would the inference be anything other than that?
And if that is if we can proceed on that basis, that in all respects, any time any key decision is made, it's a Cabinet decision, not Mr Morrison's decision personally, that might be all right for Mr Morrison, but it's a rather general way to proceed. How's Mr Morrison going to know which decisions you've characterised in that way?
Well, if they're Cabinet decisions, one would generally infer, in the absence of evidence to the contrary, that they were collective decisions, surely?
Commissioner, the risk of being argumentative, you won't have evidence of what they are because the Cabinet decisions are largely being excluded.
Well,
That's the difficulty.
if you can point me to any that show anything different, go right ahead. But it seems to me there's a sort of presumption, I'm not sure if you can call this a presumption of legality, but it seems to me a very fair and proper inference that Cabinet decisions are collective in the absence of evidence to the contrary.
All right. Well, thank you, Commissioner. That's a very helpful indication. I hadn't realised that previously.
Are you saying that you don't think that really is an inference, or what are you saying?
What I'm saying, with all respect, is that in an inquiry at this stage, when we put forward the best evidence for something, I don't understand why you don't want it. But if you don't, thank you. That's helpful. But that's what I'm
Dr.
trying
Rennick,
to
you know
understand.
that's really not the situation. The situation is that I have to determine public interest immunity, a public interest immunity objection, and I have to consider the public interest in preservation of confidentiality of Cabinet material and Cabinet committee material, and I have to consider the public interest in Mr Morrison being able to advance his position, which needs me to be able to understand why particular documents actually matter to him. And then there's the public interest in the Commission's own role of discovering what actually happened. Now, if in fact there doesn't seem a lot to discover in some aspects, then that's a consideration in the public interest immunity argument, and I may need it pointed out to me why that is not the case.
Very well. Thank you for
that.
that.
So I would prefer that you didn't say things like, oh, well, if you're not interested in having the best documents, you know that is not the heart of this argument at all.
Let me press on, Commissioner. Paragraph 43, we respectfully adopt what you've said there, but that is the purpose, fundamental purpose. We point out that in fact it's the confidence of the previous government, not the current government. And I say that because if you turn to paragraph 50 and page 12 of our submissions, you see there at paragraph 111 on page 12, the convention is that Cabinet documents are confidential to the government which created them.
I think I referred to that in my ruling, actually.
So an important factor here is that one is, to go back to Mr. Walker's point, you are dealing with a current government establishing an inquiry into a previous government and saying, we're so concerned about the cabinet confidentiality of the previous government, you, the Commission, cannot have this information. That is what the Commonwealth's saying. It's not our claim, of course, it's their claim. And so then when one looks to, if I can go through to paragraph 57, this is really the Northern Land Council is all that matters. And you see there are the general statements that we doubt whether the disclosure upon matters which remain current or controversial would ever be warranted in civil proceedings. We adopt what you said in your preliminary ruling, that is not the case here, because after all, the controversy in part arises because the government has established this commission. The next point, though, is important. The public interest in avoiding serious damage to the proper working of government at the highest level must prevail over the interests of a litigant seeking to vindicate private rights. But here, of course, this isn't about private rights primarily, it's about the Commission's rights. The Commission has been set up in the public interest to answer its terms of reference, and that is the point I'm seeking to make, perhaps not very clearly, but that's the point I'm seeking to make, that the Commonwealth is standing in the way of you fully investigating all matters. It also affects Mr. Morrison's interests, which need to be vindicated. And the quote at 58C is entirely on point here. And the key thing is, of course, that when one talks about the quality of confidence, which is essential for a PII claim, it doesn't really exist. It doesn't exist vis-a-vis Mr. Morrison, because he already knew this and he's got access to this as of right. And it doesn't really apply to the Commission either, because you've still got it. And unless you're proposing to, or counsel assisting are proposing to hand the documents back, you'll still have them. And so PII fits very unsatisfactorily. The final point is this.
Sorry,
when
can I
one
stop
looks-
you there? Are you proceeding on the premise that the documents and the statement would be produced but not published? Because one of the problems is disclosing to the world the nature of cabinet deliberations on particular subjects, which is as many authorities say, against the public interest, generally speaking.
Yes. What I'm talking about is the claim by the Commonwealth of PII in this matter, which will mean neither my client can refer to them, nor can the Commission retain the documents, because the PII claim will be upheld. Non-publication orders are a separate matter, as Mr. Walker points out. I'm talking about whether you get them in the first place at all. That's what the High Court, after all, are talking about in the NLC case and HT and the Queen. And this is my final point, Commissioner, in the public session. What is the evidence which the Commonwealth so heavily relies on here? It's extremely weak and formulaic. The statements have been read by both Professor Davis and Ms. McGregor. Neither of them, it's a class claim. There is no, and can I say, I speak as someone who's done PII claims for the last 30 years. One would normally expect to find a statement saying, this bit's really sensitive, this bit's not. And that's why I gave the example of the charter letters. It may be, Commissioner, they're of peripheral relevance to your inquiry, but the idea that they're caught by core cabinet confidentiality is very weak. They're not. The core cabinet confidentiality is what is discussed in cabinet. And to repeat myself, no one, including Mr. Morrison, wants to reveal the actual discussions as opposed to the cabinet decision and the cabinet submission. That's what should be protected here. We've already gone, in view of your preliminary ruling, well beyond the normal position in a class claim, which is you don't even begin to look at it because you accept the class is such that it shouldn't be intruded on at all. With respect, quite properly, you've gone beyond that. you've looked at documents, and in many cases when you have, you've said, this is actually very important to the work we're doing. And when I talk about what's important to the Commission, of course, I'm just acting for a witness. I don't know what you consider to be important or not, obviously. All I can rely on is the fact Mr Morrison received a compulsory notice and answered it, and that it would be incongruous and perhaps procedurally unfair if he couldn't give that answer. That's the essence of the submission I'm seeking to make. So that's the fundamental point we want to make about these matters. And I'm happy to take you, when you ask about references to further documents, of course, attached to our submissions are some further items where we point out or we ask questions about and say, well, we don't quite understand.
I can
that
help
point.
you with those, I think, Dr. Renwick.
Thank you. I'm grateful.
Give me a minute. You were right about item 11 being a misprint for 12.
Thank you.
You'll appreciate this wasn't the sort of thing where I could get a good proofreader in.
No, I understand.
And I think there's a reference to paragraph 47, which should have been 57. Now, as to the effect of the preliminary ruling, you raise these questions from paragraph 32 on. So
Yeah.
I can tell you that in relation to 32, the answer was no in relation to the preliminary ruling. It wasn't meant to indicate that those parts would go without redaction. In relation to 33, I had looked at the documents on the basis of Ms. McGregor's schedule that she attached to her statement, which dealt with a number, you'll appreciate, a large number of documents well beyond Mr. Morrison's statement. So the categorisations which I've referred to are her categorisations in that schedule. I don't know how far that gets you. Yeah, we've dealt with item 11. And you're correct in the basis on which you would say you were proceeding at the bottom of paragraph 36. And then in relation to the balance, it's effectively to say that on the preliminary ruling, those parts redacted by the Commonwealth, apart from those I'd identified, would remain redacted, subject always to what you had to say about things on behalf of Mr. Morrison. So that's where we're up to with that, if that wasn't clear.
No, thank you, Commissioner. And look, I should immediately withdraw any suggestion that the Commission wasn't interested in the best evidence. I withdraw that unreservedly.
Thank you for that.
But what my client is struggling with is the tension between, on the one hand, he's done his conscientious best to answer the notice. If counsel assisting are able to say, look, we just don't need the answers to, on reflection, this answer or that answer, then that would greatly assist us because, for example, it's obvious or it's not in contest as far as counsel assisting are concerned. As far as the Commonwealth goes, we stand ready to assist them in identifying the subsets of particular documents as opposed to what's in the submissions. And they will be small subsets, I accept, Commissioner, which support the statements. But again, we're happy to work with counsel assisting and if they say, look, it's really not an issue from our point of view about X, then in principle, we would say, all right, we don't need to refer to that in any detail. The reference in the Morrison statement is simply, if you wish to go to the detail, there it is. But we're not saying, Commissioner, you have to deal with it. Just you'll recall what happened here was that we prepared the statement, we had access to the documents, and then we invited the Commission to issue a notice for both the statement and the underpinning documents to bring this very argument to a head. and that is how more documents than Mr. Morrison really intends to actually rely on have necessarily been caught. And so, just speaking aloud, I wonder whether that is one of the ways through in all of this, providing Mr. Morrison can refer to the positive propositions he's put forward, unless counsel assisting says, look, that's not really an issue as far as we're concerned.
Well, I'd be startled, for example, if the series of events involving the settlement of the class action were contentious, but I might be wrong. Council might have a different view.
But just to take, I'm so sorry.
No, I was going to say the path you propose might provide some resolution. I'm not sure that it would solve everything, but and for that reason, I think it would be advisable that we sort out a time when a private hearing can be held, if necessary, to resolve grittier issues. But anyway, you were going to say something?
The final thing I wanted to submit was this. I mean, as I understand it, Mr. Glover will correct me if I'm wrong, the Commonwealth, in making its contents claim, is seeking to uphold the principle of cabinet government and collective responsibility. But it's not descending to saying, of course, one document is more sensitive than another. So in a sense, that's a constant. What's on the other side of the ledger then is, in a sense, what's important to the Commission and Council assisting. And some items are obviously more important, and on reflection, perhaps some are less important. It's that indication which we say will weigh heavily in any final ruling you make. And we stand ready to help Council assisting with that before perhaps we come back and take up more of your time on a private hearing. Because if Council assisting, to repeat myself, said, look, we're never going to submit that X happened on what we know at the minute, could change, then it may be that that part of the statement need not be read by Council assisting. And to conclude, as I understand it under the practice note, it's Council assisting who would be tendering the statement and reading the particular paragraphs. And one way forward might be for them to indicate if there are particular paragraphs they don't propose to read because matters are, from their point of view, no longer live issues. If we've been over comprehensive, well, I must take responsibility for that. But I can assure you, Commissioner, it was just because we wanted to give a proper and comprehensive answer.
I don't think there's any issue about that, Dr. Renwick. Well, look, we've done all the talking. I should let Mr. Scott KC have a moment in the sun, I think.
Commissioner, as I understand what's proposed by Dr. Renwick, it's that there be further discussion between counsel assisting, those assisting the Commonwealth and Mr. Morrison's lawyers as to what's truly important from the point of view of counsel assisting. That may well be a productive course, and it may well be that some comfort can be given that might render some of the matters in Mr. Morrison's statement less important to Mr. Morrison and might resolve these issues. Having said that, it's probably still prudent to make arrangements for the hearing of a private session to the extent issues can't be resolved quickly.
I think that's probably right. Mr. Glover, did you want to say anything about any of this?
If there is to be a private hearing, Commissioner, perhaps I can assist you during that session so as not to take up time now.
Mm-hmm. All right. Look, I really think, Dr. Renwick, we should try and sort out a time. I think I'd been told that you might be available Thursday afternoon, and remembering that we're going to have an hour difference between us.
Yes. So I'm doing a hearing. So it wouldn't be in person, I'm afraid, Commissioner. I'd have to have your indulgence to do it by video because I've got a hearing down here in Sydney.
Fine. Mm-hmm.
But subject to that, certainly Thursday afternoon or Friday is much better, can I say, from my point of view, if that assists you and the other council involved. And also we might give us more chance to have had a discussion before then.
That might be right, I suppose. Will that make, that's not too close to Mr Morrison's actually giving evidence, is it? Well, that'll give enough time to, I think that'll be all right. So when are you thinking on Friday, bearing in mind we've got a full day's commission sitting, so it has to be around the edges?
I think if I suggest Friday afternoon, I'd be very unpopular with everybody. What about before the hearing or at lunchtime? Perhaps before the hearing?
Provided that you're happy to, if we were to say, what, 8:45 perhaps, Queensland time, do you think that would do it?
I think so, Commissioner.
So 8:45 Queensland time will be 9:45 for you. If you're in court, that could be problematic, but if not, will that work?
It works for me, Commissioner.
Okay, how about you, Mr Glover?
Apologies, Commissioner. I have court in Sydney on that day at 10:15 in the federal court. That will only take half a day, I'm fairly confident.
Okay, so are we thinking Friday afternoon then, when we are all wishing for other things, but it might have to be then, so that'll have to be 5 p.m. on Friday, I think. So you can be available then, which will be 6 o'clock your time.
I'm very content to be available then, Commissioner, and like Dr. Renwick, I would need to appear by video.
6 o'clock your time. Did you have theatre tickets, Dr. Renwick?
The one qualification to that is that we would need access to the documents. We don't have access to all of the documents. So that would be on the basis the AGS could facilitate that in the meantime. But certainly, Commissioner, if that's the time, I mean, there may be not much difference in practice between that time on Thursday or that time on Friday. Maybe it would be better to do it on Thursday.
In some
I'm in
ways,
your hands, Commissioner.
yeah, it does seem less awful to do it at 5 p.m. on Thursday.
Yes, if that suits everyone else, that would be my submission.
Mr. Glover? That's all right.
Yes, that's convenient, Commissioner. Thank you.
And what about making the documents available? What's the position there?
I might need to look to those to my left, but the position would be generally we'll make the documents available for you, Commissioner, and those assisting you.
I can only see them.
And for us too, of course, in Sydney, please.
So there'll have to be some form of electronic access. I have to swear 42 types of oath and swear on my mother's grave before I can get to them, Dr. Renwick, so I don't think you're going to enjoy the experience. Thank you. I think that's as much as we can do for the moment, is that right? And we can all have 15 minutes for lunch.
You're content with that, Commissioner?
Sorry?
You're content with a 15-minute break?
Could we push it out? Will you? Thanks, Dr. Renwick. We don't need you anymore if you want to go about and do something else. Will you be able to finish if we start a bit later, like 2:45?
I think so, yes.
All right, 2:45 it is then. Thank you.
Thank you, Commissioner.
All rise. The Commission stands adjourned until 2:45. The Royal Commission is now in session. Please be seated.
Just before we start, I don't think I gave that last exhibit an exhibit number, but I gather 1743A is suggested, so
Yes, Commissioner.
give it that number. Thank you.
No, please. Now, Mr. Hutson, before we broke last, we started discussing the Ombudsman's investigation in early 2017,
Yes.
and you were involved in, as we discussed, in the department's response to that investigation,
Yes.
and you therefore have knowledge of the process that was adopted by the Ombudsman in that investigation.
Yes.
And would this be right? That process involved the Ombudsman providing an outline to the department detailing the topics that were to be covered in the Ombudsman's report.
With a little more detail, we had the opening meeting which we discussed before the break, and then after that the Ombudsman would have had further contact with the department, or the Ombudsman's office would have had further contact with the department in order to clarify and obtain further information, and that would have started. And then he did provide an outline, as you mentioned, of his draft report, a draft outline of his report.
Yes, and then it described in a broad sense the topics that were going to be covered in the report.
Well, it certainly went into the description of the program, the Robodebt program. It also started to identify issues that the Ombudsman had identified about the program, about the way it had been implemented, in particular. It wasn't a draft report. It wasn't a totally considered piece of information. It was provided by the Ombudsman for us for comment, and we did provide comment and had a meeting with the Ombudsman to discuss our comments on his draft outline.
And the negotiations then took place between DHS and the Ombudsman's office about the draft outline?
I don't think I would characterise those as negotiations. We had a proposition that we put to the Ombudsman in writing in terms of our response to the draft outline. I recall that I observed and mentioned to the Ombudsman that there was a significant difference between the perspective of the Ombudsman's office and the perspective of the department at that time. We had a meeting to clarify those issues. My recollection is that the Ombudsman was, in my perception, quite responsive to the views which have been advanced by the department.
Might the witness please be shown CTH.1000.007.0533_R, Exhibit 1343. Sorry, that should be, the last four digits should be 0533_R. The full doc ID will be, thank you. All right. You can see that's an email from yourself to Richard Glenn, dated the 3rd of February 2017.
Yes.
Richard Glenn, of course, was the acting Ombudsman, as we've seen from earlier emails.
Yes.
Your email says, thank you for sharing the outline with us.
Yes.
As you'll see from our comments on the attached, we have quite a long way to go. See that?
Yes.
We remain committed to working with you to resolve misunderstandings.
Yes.
So at this stage, there was substantial disagreement, wasn't there, between the department and the Ombudsman as to what was set out in the Ombudsman's outline of its proposed report.
I don't agree that to characterise those things as disagreements at this stage. The Ombudsman's views were quite preliminary. The department's views were a bit more settled, and that's why I describe it in my email as misunderstandings rather than disagreements.
Well, I'm highlighting the words "have quite a long way to go."
Yes, there was certainly a significant difference between the position outlined in the outline and our response to that. Yes.
And if we go to document CTH.1000.0007.0534, Exhibit 1343. Do you recognise this to be the outline that was referenced in the previous email?
Yes, I believe this was an attachment to that email.
Yes. And you can see various bullet points set out in the outline,
Yes.
and some of the wording is in green.
Yes.
And may we take it that the wording in green is wording inserted by the department,
I believe so, yes.
which reflected the department's position,
Yes.
and the other wording that's not in green is what was the original wording from the draft outline.
I believe that's correct, yes.
Okay. Right, and if we flick through the pages, if we look at page 2 of the document, last 4 digits 0535, do you see there's substantial sections in green?
Yes.
Likewise, the next page
Yes.
and the next.
Yes.
I don't propose to take you through the whole document unless you feel you need to, Mr. Hutson, but the substantial additional wording in green, does that reflect and be consistent with your wording in your email that there was a long way to go in terms of resolving the differences of position between the department and the Ombudsman at this stage?
In part it reflected that. It also in part reflected that, for example, and I look at the first point you have on the page that's on the screen, it reflected the fact that the Ombudsman's remarks, which you can see there are really just 2 lines, quite short, are not terribly clear in terms of the totality, and we provided further information. So if you particularly look at the term fuzzy logic, now they just say explore fuzzy logic, but then we, in our document, talk about what fuzzy logic is, that in our view it's removed from the data matching component. So it's really about explaining to the Ombudsman, to some extent, in this case, a misunderstanding about where fuzzy logic fitted into the equation. Our position was that fuzzy logic was not part of the data matching process. I might add, I'm not an expert on fuzzy logic.
All right. Can we just look at another document? CTH 3001.0034.6807_R, Exhibit 1338. We just go to the bottom of the page.
Yes.
This is an email dated the 2nd of February from yourself
Yes.
to a number of people.
Yes.
And this is the previous day to the email we've just been discussing.
Yes, okay.
And the subject is Ombudsman OCI Report Recommendation 6A and B Draft Responses. Do you see that?
In heading, yes.
The subject line?
Mm-hmm.
Oh, and in fairness, to contextualise this, we could go over the next page to the email that's at the middle of the next page. That's an email from Mr. Robinson to yourself and others dated the 1st of February 2017.
Yes.
See that? And it's got the same subject line.
Yes.
And it refers to this morning's discussion. I've drafted some potential wording for discussion at Friday's meeting with the Ombudsman.
Yes.
See that? So we'll just go back to the email I was showing you before on the first page. Call out the wording in the first paragraph of that email. And you see the words, our goal for tomorrow is to go through the paper.
Yes.
What paper do you understand that to be referring to?
Draft outline.
That we've just been looking
We've
at.
just been looking at, yes.
Okay. and it says, see if we can minimise areas of concern for the Ombudsman, see that?
Yes?
And then the words, and take out problem areas, particularly the sections on, it says and, but presumably you mean on, accuracy and fairness, you see that?
Yes?
What does the reference to take out sections on accuracy and fairness mean?
I think in particular, without going back to review the outline in great detail to identify which sections there were concerning accuracy and fairness, the word take out means to resolve the misunderstanding with the Ombudsman's office.
About what?
In this case, about particularly the sections on accuracy and fairness. So that when I use the word in this document to be problem areas, in the document that I refer to the Ombudsman, I would call those misunderstandings.
Okay. Well, we go back to the document which is cth.1000.0007.0534, Exhibit 1343. And if we go call out the bullet point comment on the 20% inaccuracy issue, and also the bit below that, section B, reasonableness and fairness of the process. On page 5, I should say. Okay. So you can see there's a bullet point comment on the 20% inaccuracy issue.
Yes.
Is that the comments on accuracy that was being referred to in that email I just showed you?
Actually, I'm not sure that it is. The 20% inaccuracy issue was actually media reporting. Media reporting said that 20% of the media reporting was that 20% of the cases which were identified by the data matching and Robodebt process were were easily resolvable. So they said that 20% of the letters that we sent were sent in error. That's actually not accurate. There was a discrepancy in those letters. It was just that discrepancy was easily explained. This 20% number comes up later in the Ombudsman's report, in which the Ombudsman mentions that the term error was not a correct term, and it's also mentioned in Ms Campbell's letter to the Ombudsman, which is reproduced in the Ombudsman report, where the term error is not correct.
Okay. Can I just ask you about the next section, the reasonableness and fairness of process?
Oh, yes. Mm-hmm.
And perhaps if we remove the calling out of the inaccuracy issue and just call out the entirety of the balance of that page, including to the bottom of the page.
Right. Mm-hmm.
Now, do you see all of that?
Yes.
Would that be the reference to the fairness aspect that's...
I believe that's correct.
Right. And when you say, said in the email, take out that part, what were you meaning to say?
In the email when I said take out means, doesn't necessarily mean there be no reference to it within the Ombudsman's report, but we take out the problem, that is the misunderstanding would be resolved.
And by misunderstanding be resolved, you mean that there'd be no negative comments with reference to the fairness of the process in the report?
That the report would reflect more accurately what was actually going on. It was a matter for the Ombudsman to decide whether those matters were fair or not.
And your objective was?
Our objective was to, our objective is to make sure that the Ombudsman report was based on evidence, which I think I also say in that email that Mr Glenn has asked for the report to be based on evidence in this particular aspect of the report, and in fact other parts of this outline, we were concerned that it wasn't based on evidence, but it was based on press reporting.
I suggest you're concerned that there'd be findings that the process, that is, the Robodebt scheme, was unfair.
That would have been a concern if that had been a finding of the Ombudsman's office, yes.
And your objective was to ensure that wasn't in the report?
Our objective was to ensure that the Ombudsman had access to all the information and evidence that he required in order to form a judgment. Whether or not he formed a judgment as to the fairness of the process was a matter for the Ombudsman. Our objective was to present what we were doing in the best possible light.
And to achieve the objective of having adverse findings about the fairness of the process not included in the report.
I think that the matter of making a decision about fairness of the process was a matter for the Ombudsman.
It was not in the interest of the department or findings to be in the report adversely commenting on the fairness of the process, was it?
No, it would not have been.
And you wanted to pursue the interests of the department as a Deputy Secretary of the department, didn't you?
That was my job.
And therefore, you sought to pursue the objective of having findings in the report about the fairness of the process not included in the report.
I repeat that our objective was to ensure that the report was evidence-based, which is what they asked for. Our objective was very much to have a report that satisfied the needs of the Ombudsman. And yes, you're right, we were seeking to advance the interest of the department.
Thank you. The document can be taken down. Could the witness please be shown document CTH.2001.0005.3244_R, Exhibit 1413. Now, you can see that's an email from Ms. Mussolino to you,
Yes, that's correct.
dated the 15th of March 2017.
Yes.
And the document that purports to be the attachment is report Centrelink's automated debt raising and recovery, March 2017. See that?
Yes. A nets markup.
Yes. And then under the words, Jonathan has discussed in bold, notes from meeting with Secretary, Ms. Golightly, Mr. Hutson, Ms. McCann, Mr. Robertson and Ms. Mussolino on 15 March 2017.
Yes. Yes.
And immediately below that are the words attached in markup are the specific comments related to the executive summary and the recommendations.
Yes.
And would you understand this to be a reference to marking up a document with markups in respect of a draft executive summary and recommendations of the Ombudsman's report?
I'm not sure that that's right. I'm not sure that it is relation to the Ombudsman's report. I mean, it may be, but I don't know for sure that that's the case.
Well, how do you explain the description of the attachment?
Well, I don't have an explanation for the attachment. The reason that I'm raising that issue in particular is in respect of points 7 and 8, and indeed 6, 7 and 8, which really aren't related to the Ombudsman's report at all. It's about a CPSU survey, hearings of the Senate inquiry, and me coming back to the Secretary with a strategy about writing to the committee. So that's why I'm a little uncertain about what the meeting was actually about and whether the executive summary, which is mentioned there, is actually the executive summary of the Ombudsman report.
Okay.
That's all.
All right, that document can be taken down. Can the witness please be shown document CTH.3005.0003.5304_R, Exhibit 1416. Okay, that purports to be an email from someone called Mario Azenza. I see that?
Marie Antoinette Azenza.
Oh, I see. I appreciate you're not a recipient of this email, but I want to ask you something about it and its attachment.
Sure. Sure.
So it's dated the 17th of March 2017.
Yes.
It notes what has marked as attachments, draft Ombudsman own motion report OCI, DHS suggested amendments.
Yes.
See that?
Yes.
And says, Dear Alison and Jason, please find attached 2 documents. It says the first one includes suggested amendments by departmental stakeholders to the draft report in markup mode.
Yes.
And then the second document is said to include comments by departmental stakeholders. See that?
Yes.
Then if we just go to one of the attachments, CTH.3005.003.5305, Exhibit 1416.
Yes.
See, that purports to be a document headed Draft Ombudsman Own Motion Report, Department of Human Services Online Compliance Intervention System for Debt Raising and Recovery, Department Suggested Amendments.
Yes.
See that? And you see in the left, well, the middle column is headed Ombudsman Text,
Yes.
and then the right column, Department's Proposed Wording.
Yes.
See that? We could go to page 3 of the document, please. And I'm calling out in particular the middle row of this table. Refers to page 1, paragraph 4 of the draft report. See that?
Yes.
And then there's some wording in the middle column, which is the original text.
Yes.
That is the Ombudsman's text.
Yes.
And then in the right-hand column is the marked up track changes of what the department was proposing to be added to the report.
Yes.
And the underlining is those additional proposed words.
Yes.
Okay. And you can see the words inserted in the second sentence after the words, we are satisfied. These words, the OCI can accurately calculate the debt.
Yes.
You see that?
Mm-hmm.
It's just been pointed out to me by my learned junior that it was already in the original draft. If you see the further words in the sentence that have been struck through, Mr. Hutson.
Sorry, which words are you referring to?
So in the next same sentence, towards the end of that sentence, 2 lines down, the wording, the OCI can accurately calculate the debt.
Yes.
It's been struck through.
Yes.
So that would have been the original wording.
Yes.
And you can see that actually in the first column.
Yes.
Yes. So I won't delay you further with that document, if that can be taken down. If the witness could be please shown document ID CTH.3007.0006.8430_R, Exhibit 1742. We can go to the second page of this email chain. See the bottom email in this chain. Call that out, please, from yourself. Date of the 13th of July 2017.
Yes.
To the Secretary's office.
Yes.
And you see the subject, Australian Institute of Administrative Law Conference -OCI Sessions.
Yes.
And it's addressed to what says Catherine for information, you see that?
Yes.
And that would be Catherine Campbell
That was the secretary, yes.
of the department.
Yes.
Okay. And it says, for information, the Australian Institute of Administrative Law is holding a conference in Canberra on 20 and 21 July 2017. The conference will include a number of sessions on issues relating to the department's online compliance intervention. See that?
Yes.
And in the second bullet point, it says Peter Hanks QC, Barrister, Owen Dixon, Chambers West, Melbourne Administrative Law and Welfare Rights, the 40-year story from Green and Daniels to Robodebt recovery. See that?
Yes.
And then towards the bottom it says a number of officers from the Legal Services Division will be attending the conference but will be instructed to refrain from commenting on online compliance issues. Do you see that?
Yes.
Do you recall sending this email, Mr. Hutson?
I don't recall sending it, no.
Right. Go up to the top of the page. There's an email which starts on the bottom of the previous page. You can see it's from the Secretary's Office, dated the 17th of July 2017.
Yes.
It says, Mr. Hutson, the Secretary has noted this advice. Please find attached a copy for your records. See that?
Yes.
Okay. And then if we go up to the next email in the chain, from Ms. Mussolino, dated the 20th of July, to the Secretary's Office, CCing you.
Yes.
Says, Secretary, update on AIL conference. Mr. Peter Hanks QC spoke at today's conference. His speech was extremely critical of the OCI program. The key criticisms are summarised below. Do you see that?
Yes.
It says none of the criticisms are new. However, noting that organisations such as ACOS and Legal Aid were present, the comments may end up in a press release or in the media. Do you see that?
Yes.
The media team is monitoring social media and other outlets to see if this gets picked up. Do you see that?
Yes.
And then it gives a summary of the criticisms.
That's correct, yes.
First point is Mr. Hanks suggested that someone should look to test the matter in the federal court.
Yes.
The third is critical of Ombudsman's report for not questioning whether the process was consistent with the Social Security law. See that?
Yes.
Fourth point suggests that raising of debts using averaging is not consistent with the terms of the Social Security law.
Yes.
And fifth suggests that the law provides no scope to put the onus on the customer to provide information that they do not owe a debt. Do you see all of that?
Yes.
Okay. And you were CC to this email?
Yes.
Do you recall reading it?
No.
Okay. We go to the next email in the chain. Call that out. Again, it's an email from the Secretary's Office,
Yes.
this time to Ms. Mussolino. See that?
Yes.
CCing you,
Yes.
24th of July 2017.
Yes.
It says, Ms. Mussolino, the Secretary has noted this advice. Please find a copy attached for your records.
Yes.
See that? And you have no recollection at all, you say, of this email.
No.
Do you know who Mr. Hanks is, Mr. Hutson?
No. Other than what's described here.
You know that he is a very experienced and eminent public law QC.
No.
Do you know that he is the author of a legal textbook on constitutional law that law students are taught at university with?
No.
And he is frequently briefed on behalf of the Commonwealth in public law matters. Did you know that?
No.
And he's appeared in the High Court on a number of occasions. Did you know that?
No.
Okay. See, this is an instance, isn't it, of the department having knowledge of an independent opinion from an eminent barrister knowledgeable in the law, as at the 20th of July 2017, that the Robodebt scheme was unlawful insofar as it used income averaging. Do you accept that?
Yes, that's what he says.
Yes. And the concern identified by Ms. Mussolino in her email is not that his opinion might be right, it's that there might be some adverse press about it.
That's correct.
And notwithstanding you say you have no knowledge of Mr. Hanks' expertise, surely an independent opinion delivered at the AIAL conference, which is the Conference for the Australian Institute of Administrative Lawyers, which you had identified in your email was upcoming, an opinion by a QC that income averaging was unlawful should have put you on notice that there was a question as to the lawfulness of income averaging in the Robodebt scheme.
I don't have any remark to make about that. Ms. Mussolino provided this advice to the Secretary, and the Secretary noted it.
Well, Mr. Hutson, you identified to the Secretary yourself that this conference was upcoming.
Yes.
And you noted who was speaking and what they were speaking about.
Yes.
So you surely had an interest in Ms. Mussolino's email about what Mr. Hanks said about the scheme.
I understand what the point you're making, but as I said, I have no recollection of this exchange at all.
Well, at the time, had you read it, would it have caused you any qualms, Mr.
Commissioner, yes, yes, I would have read it. That's certainly true. There were many people who were critical of the Robodebt scheme, and I take Counsel Assisting's perspective that Mr. Hanks is a particularly eminent person, but I didn't particularly know that he was a very eminent person at that time, and I did not know that until Mr. Scott explained that to me. There were many criticisms of the scheme, and we were dealing with those one at a time.
Right,
So
this is a criticism from a QC that using averaging isn't consistent with the terms of the Social Security law. So that's pretty specific from a specific source.
It is.
Didn't give you any grounds for alarm?
I have no recollection of this exchange at all.
Looking at it now, do you think perhaps you should have been concerned?
I've made a statement in my written statement in respect of the end-to-end legal advice that was discussed before the break. And in that, and indeed Counsel Assisting suggested that it would have been useful to have done that at the time. In my statement, I say, in response to the Commission's questions about what do I think should have been done better, I think the end-to-end legal advice should have been obtained long before that, a year before the thing was live. So, you know, that is my view now. It should have been obtained when it was live. So certainly the fact that there was a complaint or a concern raised by Mr. Hanks, who was an eminent QC, if I'd known he was as important as Mr. Scott has identified, it would have perhaps alerted a more concerted concern. But as Mr. Scott points out, Ms. Mussolino's concern, and she was my chief legal counsel, was mostly about the potential for media commentary.
Well, I suggest to you that the reason you didn't pay any attention to the legal implications of what Mr. Hanks was reported as saying was that your only interest in it was the potential media implications.
I'm sorry, I didn't quite catch that.
I suggest to you that the reason why you didn't pay particular attention to the legal implications of what Mr. Hanks was reported as having said was that your only interest in this conference was the potential for adverse criticism of the department that might be reported in the media.
That was what's put in Ms. Mussolino's note, yes.
Well, not only that, you reported the prospect of this conference in your email to the Secretary prior to Ms. Mussolino's email.
Yes.
Well, why did you do that?
Commissioner, and that's probably a good question. I'm almost certain that this would have been brought to my attention by Ms. Mussolino. Ms. Mussolino would have asked me to suggested to me that it would be something that I should bring to the Secretary's attention, and she would have drafted that note that I sent to the Secretary.
Well, can we just go back to the first email on the first page at the bottom of that email chain. No, the first email. Sorry, the second page, first email. Pull that out again. You see the last line says the General Manager of the Community Engagement Division is aware of the conference, noting that there may be some prospect of media interest in the sessions relating to debt. And what's the Community Engagement Division?
Community Engagement Division is the division that managed media within the department. So the media branch that we spoke about earlier that did the weekend top stories, that was within Community Engagement Division. So the General Manager of Community Engagement Division was responsible for really communications with external to the department and internal to the department.
And then the next sentence is the Minister's Media Officer will be informed.
That's right, yes.
And this is an email that you sent, isn't it?
Yes.
And so the issue of concern that you identify in this email was the prospect of media interest in the conference.
Yes.
And I suggest that that was your only interest in this conference.
At this stage, yes.
And in what Ms Mussolino then said about it in the email to the Secretary's office CCing you.
Yes.
Thank you. That can be taken down. Ask you a couple of questions about your statement. Go to paragraph 16, your supplementary statement, that is. Call that out, please, on the screen. On page 10 of that statement.
Yes.
The opening words in the second paragraph. Sorry, I should read the full paragraph. You say, in early 2017, you had concerns about issues with the implementation of Robodebt.
Yes.
You say, for the most part, these concerns were referred to in the Ombudsman's report and were addressed by the DHS.
Yes.
When you say for the most part, were there concerns that you had that weren't addressed?
There was one. If you read the Ombudsman's report, one of the issues that I was particularly concerned about was the usability of the system. That issue had not been addressed by DHS at the time that the Ombudsman's report was published. It was still underway.
Do you mean the usability of the online platform?
Yes, yes.
Okay. It wasn't user-friendly enough?
No.
Did it ever get made user-friendly enough?
I understand that there were two goes at making it more user-friendly. The first was in the early part of 2017, and then it was replaced by a new system known as QPI, Customer Update Payment Information, or something of that nature, which made it even more friendly. But that was after my involvement ended.
In paragraphs 17 and 18, you refer to the issues with mailing letters to people.
Yes.
Where no response was received. See that?
Yes.
And you make the specific observation that members of the target program were often not current recipients of the program, and so they would not have kept their address up to date, as there was no requirement for them to do so.
Yes.
And so the department's addresses were out of date.
Yes.
And so letters were being sent en masse to people to the wrong address, in effect.
Yes.
Okay. In paragraph 19, you say DHS attempted to resolve this issue in early 2017 by using registered mail so that there was a record of receipt by the customer.
Yes.
I'm just interested in your word attempted. Do you consider it was resolved or was not completely resolved?
In my mind, that was uncertain. If I send a letter using registered mail to the wrong address, I've still, even though I'm at that stage then have a record that it was not received, or if it was received, that someone signed for it, I'm not entirely sure that that was complete in terms of resolving the issue. So that's why I said attempted, because I don't have in my own mind enough information to be able to answer, yes, it was definitely fixed.
Paragraph 20. You make the point that Centrelink phone numbers were omitted from the initial letters by design.
That's correct.
And that this was to alleviate pressure on DHS call centres.
No, you've missed the middle sentence.
Oh. So DHS frequently wrote letters without phone numbers.
Yes.
And then the next sentence is this was to alleviate pressure on DHS call centres.
That's correct.
So your point about the phone numbers being omitted from the letters by design, is that related to the point about to alleviating pressure on DHS call centres?
Okay, so, and I think the last sentence is relevant as well about the complexity of the matter. There were a number of different letters and call centres were under a lot of pressure. So it wasn't uncommon for the department to send a letter about some, I might say, relatively minor matter and not incorporate a phone number. There were certainly significant numbers of customers who frankly enjoyed someone to call, and as I said, departmental call centres were under a lot of pressure. Keeping the call centre wait times down so that people who really did need to contact us was important. And so those phone numbers were omitted from letters. In my view, the complexity associated with the Robodebt matter meant that those people certainly needed to have access to a phone number. It was particularly the case because it was a special phone number.
Right.
So what was the design from your perspective behind not including it on the Robodebt connected letters?
Commissioner, I got no idea.
How do you know it was omitted by design?
Well, because I know it wasn't omitted by error, which is the alternative.
How do you work that out?
I think really my mind is around conversations that happened at the time. I actually thought to myself, and I think I refer to here, I can't understand how we designed the system without having the phone number in the letters. It just seemed to me to be extraordinary, particularly when we had a dedicated line.
So you refer to conversations at the time, who with?
I don't have any particulars to tell you that. So if you really want to say, how do I know it was by design? Because I don't think it was by error. But I can't give you particulars as to why I think that.
Okay. Can I just take you back to page 3, para 13 of your statement? Call out.
Oh, yes.
Refer to in the last two sentences. In your document review, you noted advice that Ms Wilson and Ms Golightly had met the then Minister for Digital Transformation,
Yes.
Angus Taylor, to present on the Robodebt scheme in January 2017.
Yes.
Were you there in that
No.
meeting? Okay.
You know anything about it or what it was for?
In my document review, Commissioner, there was a reference to it, or perhaps even a noting of it. At that stage, the Minister for Digital Transformation obviously expressed an interest in the Robodebt scheme, and there was a meeting to present the Robodebt scheme to him, and that was held in January 17. I only really noted this. I mean, the reason I put this in my statement was in response to a request from solicitors for the Commonwealth, who said that it would be useful to identify for the Commission those things that might have changed my perspective as a result of having watched the evidence and I watched Ms Wilson's evidence, and I don't remember her mentioning this meeting, that's all.
Right, thank you.
What was the nature of the document you reviewed?
Oh gosh, I can't recall exactly. It wasn't an email. I think it might have been either a note to the secretary might have either been a note to the secretary or perhaps a brief to the minister of some sort. I really can't remember, I'm sorry.
Okay. All right, I want to come back to page 12 of your statement. Call out paragraph 28. State in the first two sentences, it is my view now that income averaging is clearly an imperfect substitute for accurate fortnightly income data. Using income averaging to calculate a debt will rarely produce a result that equates with actual fortnightly earnings. You see that?
Yes.
And that's because, isn't it, Social Security recipients often have incomes that vary from fortnight to fortnight.
Yes.
It cannot therefore be safely assumed without evidence that the recipient's fortnightly incomes are accurately reflected in a calculation using income averaging.
They cannot be accurately reflected. That's right, and that's right.
And you knew this at the time that the Robodebt scheme was being implemented.
At the time when the Robodebt scheme was being implemented, I understood that using income averaging was authorised by Social Security law.
Well, I'm not asking whether you thought it was authorised, I'm asking whether you realised it was inaccurate.
Well, the question is a little different, I'm afraid, because the point here is that if it was authorised by Social Security law, then under the law it wasn't inaccurate, it was merely different. So if the law provided that a person could have income as they declared it, used to calculate their payments, or indeed, if they chose not to declare it, the law provided that income averaging could be used, then yes, there was a difference, but it wasn't inaccurate, it was merely complying with the law.
Well, I'm asking you the accuracy of the calculation as a matter of maths.
No, a different calculation, not accuracy. If the law authorised the use of income averaging, then it would have been an accurate calculation.
Will you answer my question, please, Mr. Hutson? Would it be an inaccurate or accurate calculation using income averaging to calculate how much a person was earning each fortnight?
It would have been accurate.
You're saying it would be accurate to calculate someone's actual fortnightly earnings?
No, that's not what I said. What I said is that the calculation of the amount of payment the person would have received would have been accurate if it had been properly authorised by Social Security law.
So you're saying that, so if I can just understand your evidence, are you asserting that mathematical accuracy is determined by what you believe the Social Security law said?
Mathematical accuracy of the payment to which the person was entitled was determined by Social Security law.
I'm not asking you what you believe the
I don't
person...
know that this is productive. I can tell you, Mr. Hutson, that the law can deem non-facts to be facts and the untrue to be true, and
Indeed.
It doesn't follow that because it's legal, it's accurate.
Yes.
So I think all that council is trying to get from you is that, setting aside the lawfulness of it,
Sure.
you wouldn't necessarily come up with an accurate result if you did it this way.
You wouldn't come up with an accurate fortnightly calculation of a person's earnings, no. You would have a different calculation, that's true. Absolutely, Commissioner, I agree with you.
Thank you, Commissioner. Now, in the same paragraph, Mr. Hutson, you say there are circumstances when using income averaging is beneficial to the client and circumstances when it is not. You see that towards the end of that paragraph?
Yes.
You say for many or most people it was detrimental and for others it was beneficial.
That's correct.
See that? It says this was also identified at page 2 of the 2017 Ombudsman's 2017 report.
Yes.
See that?
Yes.
You know, can you give any proportions to that? How many actually turned out
Beneficial.
average? And I assume it's beneficial in the sense
Yes,
that the
yes.
amount of debt raised would be less if somehow it worked out that the averaging produced fewer fortnights where they were in trouble.
Well, indeed, and Commissioner, I gave some thought to this particular thing. I don't really have an indication of when it more or less. My sense is, and it's my sense, that most people would have been adversely affected. There were some people who would have been beneficial. And the one example I bring out is if you have a student in the last year, and this is hypothetical entirely, if you have a student in their last year of study, they're receiving student allowance, and for the last 6 months of study, they decide to get a part-time job so that they can save money. They don't tell Centrelink about this job at all. They just earn income, right? At the end of the academic year, they come off payment and they travel overseas. They receive no benefits at all, and they spend all of their money. If you applied income averaging using that example, the income that they would have calculated would have been about half of the money they actually made, because it would have been spread over an entire year and not just over the period that they earned it. Now, that's a hypothetical example, and they're probably, I'm sure other people could think of others, but that's just simply one hypothetical example. Clearly, if from my view, the problem would have been more detrimental where you had a more common set of circumstances where the person had differing income each fortnight.
Thank you, Commissioner. Just asking you about the last sentence in this paragraph. This was
Yes.
also identified at page 2 of the 2017 Ombudsman's report.
Yes, that's correct.
Can I just ask the witness please be shown CTH 3004.0010.5247, Exhibit 1220.
Oh, yes. Mm-hmm.
See that? You recognise
Yes.
this?
This is the final report, isn't it?
It is.
Yes. Mm-hmm.
If we go to page 2 of the report, last 4 digits is 5251.
Yes.
Call out the words "our investigation revealed," that paragraph in the middle.
Mm-hmm. Yes.
See the words, in some cases this was a more favourable outcome for the customer, and in others the debt was overstated.
Yes.
Is that what you were referring to in paragraph 28 of your statement?
Yes.
Okay. The witness please be shown document CTH.3005.0003.6060_R, Exhibit 1420. See, that's an email from Mr. Robinson to Louise McLeod.
Yes.
Louise being of the Ombudsman's office.
Yes.
Says Louise, attached is the marked up version following today's discussion and feedback from other areas.
Yes.
Okay, and then can the witness please be shown CTH.3005.0003.6061, Exhibit 1420.
I didn't receive this document, did I?
No, you didn't.
Okay, good, fine, thank you.
Well, I'm not suggesting you did.
Okay, thank you.
That document please be shown. That should be CTH.3005.0003.6061, Exhibit 1420. Thank you.
That's the draft.
This is the attached draft.
Um,
And if we go to the
okay, yes, okay.
first page, heading Executive Summary. You can see the draft marked in track.
Yes.
If we go to the second page, pull out the paragraph in the middle, commencing with the words, "Our investigation found."
Yes.
You can see the last sentence there.
Yes.
You can see the words in underline,
Yes.
being words that have been added
at the suggestion of the department, yes.
Yes. Were you aware that the passage from the final report that you referred to in paragraph 28 of your statement were words that have been inserted at the suggestion of the department?
No.
Okay. Finally, Mr. Hutson, could you be shown document CTH.300.007.3585_R? Commissioner, I don't believe this has an exhibit number as yet.
Okay.
We scroll to the next page. You can see from media to media.
Yes.
You can see, please find below today's Department of Human Services top stories.
Yes.
And then if we call out further down the page, middle of that page, the reference to the Slater and Gordon article.
Yes.
Okay, we take that away. You can see this is an email the 21st of January 2017.
Yes, we discussed it this morning.
Yes. We go to the previous page. We call out email on the bottom, 21st of January 2017.
Yes.
You see that that's the same email about not wanting to scare the horses.
Yes.
And then we call out the email in the middle of the page. It's from Ms. Golightly to you. Sorry, should have also said that I'm happy to talk this through as there are a number of ways handling, but would appreciate your advisory strategy. See that?
Yes.
And then if we call out the final email at the top of the page. See, that's from you to from Miss Mussolino to you.
Yes.
Seeing someone called Maurice
Mara Steepniks.
Steepniks.
Mm-hmm.
Thank you, 23rd of January.
Mm-hmm. Yes.
And you can see Ms. Mussolino says, I don't think there is a legal advice, internal or external, it considers the end-to-end process. You see that?
Yes.
And then there's a list of possible legal issues.
Yes.
Is that further email you were referring to when I was questioning you about this, about the emails at about this time in relation to the Guardian article?
Yes, that's right.
Thank you. Commissioner, that's the evidence of the witness.
Well, what came of that? You got that email, so
I'm sorry, that was the 20, without looking, I'm pretty sure it was the 23rd of January. Yes, 23rd of January.
so what did you do about it?
Well, as I gave evidence this morning, Commissioner, after that there was organised a meeting between Ms Mussolino, Ms Golightly and myself to discuss that issue. And as I also gave evidence this morning, I have no recollection what happened as a result of that, whether we commissioned this advice or otherwise. In my statement, Commissioner, I say I think this advice would have been, frankly, very useful a year earlier before the program went live.
Okay, but you had it in 2017, and she makes a number of points about areas where there are legal questions,
Yes.
and it just goes off into the ether, does it?
Well, I don't know. I don't know. I really don't. I don't have any
As far as you
recollection.
were concerned, it did, didn't it? Because
Well,
you did nothing about it.
No, that's not correct. There was a meeting about it, and what I don't know is what happened at that meeting. So there are a number of outcomes that could have happened at that meeting. We could have asked Ms Mussolino to organise the advice. We could have deferred it for some reason that I can't recall at the moment. We could have suggested we seek some further consideration before we commissioned the advice. I just don't have any recollection.
All right, thank you. Anything, Ms Hogan-Doran?
No, Commissioner.
Thank you.
I'm sorry, I should have tendered that email, Commissioner.
Yes. Are we being careful not to disrupt another exhibit list? Is that the situation? So 1743B?
Yes, please, Commissioner.
Thank you.
Oh, sorry, it can be 1744.
You can?
And sorry, before instead of saying that that's the evidence of this witness, I've just had a note passed by my junior, so.
Oh, okay. 1744 anyway for that exhibit, if that's right.
Commissioner, just while that's being done, if I might be of assisted to note that although it hadn't been tended by council assisting, it is referred to in Mr Hutson's statement at footnotes 39, 41 and 43.
Thank you.
Commissioner, that is the evidence of the witness.
Thank you. And Mr Hutson can be excused.
You can, Commissioner.
Thanks, Mr Hutson.
Thank you very much.
Excused. All right. Anything else for the afternoon?
That concludes the evidence for the day, Commissioner.
Okay. 10 o'clock tomorrow then, thanks.
All rise. The Commission stands adjourned until 10 a.m. tomorrow morning.